Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault,
Hello.
and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring
relevant.
the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Literally not true.
Dati mihi Anglican, please. Verbal Latino. I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Happy Friday. Oh, I just got rid of chat. Where did chat go? Come back. There we go. Who was first in chat today, by the way? I'm curious. Curious who was first up. Reset this counter for y'all so you can make the number climb again as you do. We're already at 87. Thank you very much for that. Oh man, they just finished. Stu there in the chopper in California. They just finished that video. Just left, they ended it, so bummer. All right, great commentary by Stu as always. Hope everything goes well for the man on the bridge. Obviously somebody in distress needs some help. Hoping nothing terrible happens. Oh yeah. We're headed back to trial right now. Who was first? I don't know. Yeah, I saved it for later consumption as well. Let's see. We had in court. I didn't want to come right back because we're just doing the jury instructions. And oh, thank you. We hit 100 likes, just like that. Bing. 105. We're just doing jury instructions, which is great. We like them, but let's listen here. I think we just went to, okay, closing arguments. Just finished jury instructions. This is live, by the way.
You've all heard the evidence now, and I want to go over a little bit more about what the judge was talking about with jury instructions and kind of point you in the direction where I think the evidence went today. He just read you the aggravated assault instruction, and that's how it looks. And I'm a visual person, so when I see things, it sometimes helps. So it's a 4-prong that there's a threat, that there's an ability to carry out the threat, and that the victim, David McKee, was scared, and then the assault was made with a deadly weapon. So what are we talking about here? The threat we're talking about is you're going to find out, right? Do you remember when David McKee said that? You're going to find out. So that's the threat. But then what happens after that? The shot. The threat and the shot together combined is what aggravated assault is. And then ultimately we see David McKee, he hops in a car and he drives away. He calls 911. He tells us he was afraid of his life because the threat and the shot. Now you remember in jury selection, we talked a little bit about what does it mean to shoot up like this? What does it mean to shoot like that? You know, somebody testified that that's a warning shot. So when you have a threat and you have a shot, a lot of people in their reasonable minds believe what's coming next is a shot at me. And that's what David McKee testified today. He was afraid that he was going to get shot at, so he left. There's specialized instructions, but a deadly weapon obviously is a firearm. And great bodily harm means that you think something bad is going to happen to you. We don't have to prove that he had intent to kill. We just have to prove that he intended to scare David McKee. Now, the judge talked a little bit about lesser included, and again, I'm a visual person.
Can you make
and
that
this
smaller?
is what your verdict form will look like. But there are lesser included, and I want to go over them. The first lesser included is called an improper exhibition of a firearm, and that's basically misusing a firearm. Misusing a firearm so that it might scare somebody in a rude, careless, angry manner. That's what it is. Maybe shooting a gun, you're not intending to make somebody mad, but you misuse it. And that's a lesser included. And we know that a shot was fired. And how we know a shot was fired was because the neighbor heard it. And the neighbor tells us, I hear shots from time to time in my neighborhood. But what was special about this shot being fired is shortly after David McKee is there and scared and calling 911. Another lesser included is assault. An assault is basically a threat. Come at me, bro, would be a typical assault. But if you'll notice, this one doesn't involve a firearm. It's just saying something with the intent to scare someone. That's what an assault is. So when you look at the verdict form, we definitely know an assault occurred because you're going to find out those words are an assault, right? We definitely know an improper execution of a firearm happened because the shot was near McKee, right? But what the state has proved is we proved both, that the threat happened and the shot was fired. So the highest level has been proven, but we've proven all of the lesser included. So as we sat here today, and I know this has been a pretty quick trial, you heard from the victim, you heard from the mother, you heard from the neighbor, and you heard from the two officers. You also heard from Cole Fruit kind of explain how the day started, and then we heard from Dan Estes, who kind of evaluated the evidence. The evidence that we did put into evidence would be the 911 call, which we heard. And then the video is a short muted video, remember? And we watched David McKee drive from the neighbor's house to the location he says he was at when the incident occurred. And then we kind of looked at a shot of the video to kind of determine where everybody was standing. So when you look at the evidence, you need to make sure, and the judge has read this, this is where you get to determine who you think is telling the truth. What makes sense? Are people testifying, does it align with the evidence? Does it align with the timeline? These are things that are really important to take a look at. And finally, you've just heard the reasonable doubt instruction, but I do want to caution you, if you have to force yourself or you have to imagine, or if it is so hard to kind of think that there is a doubt, that means there's no doubt. There's no reasonable doubt. And if you find that the elements have been proven in that he made that threat, he shot that gun, you must find him guilty of aggravated assault with a firearm. Thank you.
Thank you, Ms. Wood. Mr. Morris?
That was quick. Times New Roman font, I guess.
Thank you for y'all's patience today. I know we may say it's a quick trial, but you've been invested for about the last 6 or 7 hours, and that's a bit of a day already. As I started in the opening statement, I told you about what my father had to say all the time when I was raised by him, which is honesty keeps your story simple and your reputation clean. Honesty keeps your story simple and your reputation clean. Just if you're straight with people, it rings true. And if that's true, why is David McKee's testimony so complicated? Mr. McGee said that he saw Mr. Mills on the porch with a 9mm. Then he saw Mr. Mills behind his car with the 9mm. Mr. McKee testified that Pete is a serious problem around the neighborhood and characterized his size as that of a Great Dane. He told this jury that while they were on the property, Mr. Mills lost it in front of the DEP staff. Matter of fact, used foul language in front of DEP staff. And that was the reason for Mr. Frew taking the stand. Do you have any kind of recollection of this? No, everything went pretty well. Time and time again, Mr. McKee's testimony is exaggerated. And in some instances, it's just an outright lie. I don't know if these disputes have actually gotten to a point where a family is ready to raise an ante this high, but it feels that way. Photographs of the properties were provided to you. You'll have the opportunity to take a look at it. You cannot see through the brush. And if we believe Mr. McKee was located where he told law enforcement he was at the time of the shooting, that makes all of this really peculiar. He's testifying he could see through a wall of greenery. Now, I've tried a couple of times to figure out through testimony of the state, when was this newfound improvement? The rocks, the bedrocks, the work done on the front end of the property. the thinning out. There was only a 3-month difference. If we take a look at April 7th, when the incident was to have occurred, and we take a look at, I think it was July 13th, when Mr. Estes said he went out there, you're talking April to May, May to June, June to July. Talking about 90 days. I don't think in those pictures you see any kind of upgrades to the property. And if I'm wrong, I'm wrong. But take a look at those photographs. Does it look like any improvements have occurred? Does it look like that barrier has been thinned out? I mean, the reality is, I mean, a dog can go bury itself through thorns and bristle and whatever else, but that doesn't mean you can see through it. Photographs of Pete. This is another example where Pete's a Great Dane and he's vicious and he's public enemy number one. But when you take a look at Pete in pictures, he looks a lot like a dog. He looks like a lab mix. And this is one of those other concoctions, those exaggerations of Mr. McKee. And the exaggeration doesn't play out so well in photographs. Mr. Estes said that he came in contact with Pete and that, you know, the dog was playful. The dog was licking at his hands. But the dog is not a danger to the neighborhood. We've already been through what he had to say, but it's important to recognize that Mr. McKee is prepared to say what he needs to say. He's prepared to say things that demonstrably didn't even happen. We're talking about DEP staff saying, look, it was a walkthrough. We talked to both sides. Everybody broke apart. We found nothing. Apparently, Mr. Mills was the complainant. People have the right to complain about issues with erosion, so they call DEP. That's not the end of the world. But what is incredibly peculiar is why someone would raise their hand and swear that there was a melee out there. And not to exaggerate myself, but at least an argument out there that raised blood pressure enough to tell someone to F off in front of a DEP officer. It just didn't happen. It's not like there was miscommunication. It's not like he said, screw off. It wasn't like we were hedging things. It just didn't happen. So why would somebody do that? Mr. Estes had the opportunity to survey the property. And no one's doing this stuff for free. I mean, you know, you can't get someone to give you gas for free. You can't go to a restaurant and eat for free, maybe unless you know the owner. But in any event, and the fact remains is if you want someone as a defendant, if the defendant wants someone to come out and survey a scene, as law enforcement should have done, then you're going to have to pay them to do that. It doesn't mean that Mr. Estes was bought. It means that he did a job. He went out there and he looked over everything and he took measurements, which is more than what I can say for the sheriff's office. I mean, we keep hearing 50 to 60 feet over and over and over again. But Mr. Estes, who really does not have a dog in the fight, he went out there to conduct an evaluation of the distance, to measure the distance. And he knew what Mr. McKee had said, where he was. And he was able to measure that out. And it is twice as long, probably close to 3 times the distance. So now we've got what? We've got distance. And the farther out I go from you guys, the harder it is to see details. 130 to 150 feet is vastly different than 50 to 60 feet away. That 50 to 60 feet makes it sound like, you know, they were really close to each other and you could make out certain details. So I think the entire McKee family, Veronica McKee and David McKee, were willing to say that they have had problems, issues with the erosion issue, with the improvements issue, and with Pete the dog. it's curious that Mr. McKee would say there were no history of issues between he and Mr. Mills. But out of the blue, when you go from 0 to 150, he's saying that he's just calling out to Lee, to get Lee to get the dog off his property. He's ready to go. And Lee decides, this is what's supposed to make sense. They get into a discussion about, getting the dog. And out of the blue, Mr. Mills, who has no prior issues with Mr. McKee, pulls out a gun and fires it. That's extreme. So then we need to ask the next question. What did he see, which he couldn't see? And what was the nature of the firearm? And what evidence is there that can attach a conviction to Mr. Mills? That's really quite the question, because Mr. McKee is all over the road. And it starts with the kind of weapon. So he's just naive when it comes to guns. He's just a trucking guy. Except we come to find out really it's not exactly the case. He does own firearms. And he actually admitted that, he did say that when asked by law enforcement that he thought it was a black Taurus 9mm and it had a clip. That strikes me as specific. It's one thing for somebody to go to a dealership and say, hey, I want a car. I got a price range, but I'd like to get a car today. Versus someone who walks in and says, I want a Jeep Wrangler and I want it to be green. But I don't really know anything about cars. But I know a Jeep Wrangler when I see it, It's incredibly specific for someone who didn't really have the time to see the gun. It's strange. It's another example of an exaggeration on his part. So where is the gun? Well, that falls into the lap of the sheriff's office. And that goes directly to Deputy Ayden Tate. So Deputy Tate indicated that what his investigation did not include. We're talking about a serious criminal offense that's entitled to a serious investigation. We didn't conduct a search warrant for the house. He said, well, there wasn't probable cause. Well, judges make that determination. Officers don't. Every day, officers believe that they have probable cause. They go to a judge. A lot of times, judges they sign the warrant or the search warrant. But he decided on his own, and he didn't have enough. That's a little peculiar. It almost sounds lazy. He didn't conduct any kind of gunpowder residue exam on Mr. Mills, his hands, or his clothes. That material stays on clothes for quite a while. He didn't want to do a search warrant for the house. What could you have possibly found? Maybe you would have found a Taurus. Maybe you would have found the clothes that had the gunpowder residue on it.
Why would you suggest he'd had a Taurus? Not helping your
Did they
client.
canvass the neighborhood for independent witnesses? Did they go door to door and ask, hey, did you hear a gunshot? Because gunshots are typically pretty loud, very loud. But we have two people in the middle of the day who heard that gunshot, ready to swear to it. It's his mother, who also is frustrated by this ongoing dispute, and it's his lifelong friend. And it's his lifelong friend, actually, who indicated that David knows how to operate guns. And David knows the difference between a 9mm and a revolver. I can't get into the mind of a mother, but I can certainly understand why, if her son is in a bind, she's going to want to help her son. She's also not exactly the greatest fan of Mr. Mills, but taking a local petty dispute or disputes and raising them to this level is unreal. It boggles the mind. And at least the sheriff's office could show us a picture. This was the gun. And what am I holding up? I'm holding up what the sheriff's office gave us. This is the gun. And this is the report of the gunshot residue. And these are all the people right over there who had their doors knocked and were interviewed by law enforcement. Nobody. Again, if you're going to conduct a serious investigation, you've got to be serious about it. To say that this investigation was bad is an understatement. And if we've got a gun, I know what else we got to have, especially if it's a Taurus 9mm with a clip. Gunshots fired, you've got a shell casing. So either Mr. Mills, in the heat of the moment, was able to locate the shell casing and take it inside, or they conducted a search of the area, which is what Tate said, and they didn't find a shell casing. Can anybody give any evidence that a gun was even pulled? Well, there's David. David said he saw from chest up what was going on with Mr. Mills from essentially 150 feet away. He pulled the gun up. Well, then he had testified that he saw him pull it from the waist. But the waist is now the chest, and the chest is the waist. It's kind of like trying to clean up after the fact. I don't know of anybody that wears a belt around their chest. He didn't either. But if we're going to have evidence to prove someone guilty, you know what we need? We need evidence. And you can't say, well, I think that he shot in my direction. I mean, when he pulled the gun up, and then I ducked, I don't know where he shot the gun. I don't know if it was at me in the air, on the ground. Even the 911 call, the dispatch asked, he dodged the question, didn't answer the question. Did he shoot in the ground? Did he shoot in the air? Didn't answer the question. Why can't he answer that question? One of the things that I thought was incredibly remarkable about Deputy Tate. Deputy Tate, as you can see, he's not done by a long stretch. He's a smart young man, and he's a deputy sheriff, and he handled this investigation. Maybe he had a bad day, but this was a horrible investigation. But the fact of the matter is, he more than strains credibility when you are familiar with firearms. You shoot every day, or that may be an exaggeration, but he's got to be knowledgeable about firearms just by virtue of being an officer on the beat. He's got to know how guns operate. He knows the difference between a revolver and a 9mm. And for some reason, he sat over there and he wanted to play with everybody and hem-haw about the difference. Did Zorowski, did he hem-haw about it? No. There's a difference between a 9mm and a .38. There is a clear-cut difference. With a revolver, you have a chamber. A .38 is a smaller pistol. You don't rack a revolver. Deputy Tate knew better. But it's almost like when my kids were little, you had that toy where you got all different types of cutout shapes, and you're supposed to put one of those shapes into the box. But it was round, and you're going into the square. You just push, and it's not going in. But that's exactly what it felt like Tate was doing. You know, sometimes 9mm just looks like a .38. That does not compute. It would be refreshing, frankly, for him simply to have said, there's no question but that they're different. They look different. Now, the excuse might be this, that, or the other. Maybe he couldn't see this, that, or the other, or something was problematic other than. But to sit here in front of this jury and say they're the same, essentially, it speaks to the credibility of not only the investigation, but of his testimony. The prosecution bears the burden of proving a defendant is guilty beyond a reasonable doubt. And this is the strictest standard in our legal system. The state went through the elements. And I don't think I'm being very bold to say there's not a single element that I believe was met. You got to have a gun. Now, we've got plenty of friends and family that are willing to say, I heard a shot. But where are the other witnesses? Somebody else had to hear something if a gun went off, but there's nobody here. But we've got Mom here, and we've got Mr. Smith here, and they're willing to say it. In order to find Mr. Mills guilty of, frankly, this charge, there's gonna have to be a gun. We can't just play like it's supposed to, we're just supposed to think it into existence. There's not a shell casing, there's not a gun. I don't know that you have anything. And then we're gonna get to the lesser included options, like an assault. Let's just say, for example, they were bickering with each other. That's not going to get you to an assault. He's over 150 feet away. Or even if you just say that he's 60 feet away, if we take David McKee's statement that it was only 60 feet away, if I'm yelling at you from 60 feet away, are you really in fear of violence? Not a reasonable person would be. And then you have to ask yourself, what is it that would disturb somebody so much that they would carry a firearm days after? There is no evidence that we can provide to you, no physical evidence, but threats were made that day. And Mr. Mills tried to go on his own way. Mr. Mills just decided, I think he understood that this dispute has gone way too far, but he got the dog. He was finally able to get Pete back, and they went on a walk. The state's allegations, as I've indicated over and over, are based on testimony from a man who cannot keep his story straight. He couldn't with dispatch. He couldn't in his initial conversation with officers at the scene. And then when he got a tape statement made, he changed the story again. You don't know where the gun was. You don't know where it was fired. You don't know what kind of gun, except he said it was a Taurus. There's no indication of a 9mm being anywhere on that premises. And then, the state may say, well, guns are guns. People aren't really all experts in guns. Okay, yeah, but he even admitted he knows the difference between a revolver and a Taurus, and he specifically said a Taurus with a clip, a black Taurus. Again, it's a Jeep Wrangler at a dealership. I really don't know cars, but I would like a green Jeep Wrangler today. Okay, well, it sounds like you know your Jeeps. At the beginning of all of this, I said that I was going to come back to each of you after all the evidence had been presented and ask you for a not guilty verdict. So here I am, and I'm telling each of you, we have an obligation to do real investigations if we're going to charge real criminal offenses, felony criminal offenses against our own people. and they didn't make it by a long stretch. And this situation has gotten way out of hand. And I'm asking for a not guilty verdict today for this and any other charge. Thank you for your attention.
And state
Yes,
rebuttal.
Lord?
Okay, screen again.
I think defense did a good job in closing. I think also that a jury could reach the
This
conclusion.
case kind of
it did
boils
happen.
down to three terms: bad news, bad temper, and a bad decision. I'm going to walk you through how we know what we know about this case. But I think it would be easier to kind of look at the things we agree on first. We know that the DEP complaint was initiated by the defendant. And we know that because Cole Frew had to look at his deposition and tell us, oh yeah, I did look it up. The defendant did a DEP complaint. Now, what's important about that DEP complaint? It's similar to making a code enforcement complaint on a neighbor. Maybe your neighbor has a deadbeat truck and you want it out so that the neighborhood will look good. So you make this call, and when you make that call, what you're hoping for something to happen is for the code enforcement to say, hey dude, you got to get rid of the truck. That's what was happening that day. Is Mr. Mills wanted the DEP to tell the McGee family, hey, you got to do something. And when that didn't happen, the day kind of went off in not the manner I think Mr. McGee recognized would, or Mr. Mills. But we all know that the day started because of this complaint. We also know that the DEP advised of the outcome that day because Mr. McGee tells us that he told us, hey, I don't have to do anything. They determined it was an issue with Florida water management. So that's the whole reason why he's calling his mom. Good news, Mom. We're not going to have to spend money fixing this problem. DEP says everything's good. Now, you earlier heard that Mr. McGee said that while this was going on, Mr. Mills was having issues with one of the DEP people. And he said that there's no evidence of that. Mr. Frew came in and said that Mr. Mills was completely polite to him. But Mr. Frew also told us that his coworker took Mr. Mills aside and explained the outcome of that DEP investigation. And Mr. Frew told us he didn't know what Mr. Hetrick, the other guy, said to Mr. Mills. Now, according to Mr. McKee, he said that also happened, is that we were taken aside by the other guy, not Mr. Frew, and kind of told the outcome. And that's where things got a little aggressive that day. So that is all backed up by Mr. Frew's testimony. Another piece of evidence we know to be true, and we've heard it from multiple people, is Pete the dog roams the property. We've heard this from Dan Estes. We heard it from the mother. We heard it from Mr. McKee, that Pete the dog is just kind of around, and that's what he's doing. We also know that McKee, according to McKee, didn't get a great look at the gun. Now, he's got two reasons why he didn't get a great look at the gun. Number one, he remembers ducking. He saw it and he ducked. Number two, the reason he didn't get a great look at the gun is he didn't have beef with Mr. Mills. He wasn't expecting a confrontation. He was there because they'd gotten along. He was the easiest party to deal with. So he didn't have his eyes on Mr. Mills the whole day anyway. And that's why he didn't get a look at the gun. Now, we've talked a little bit about the specifics, and he told us how it went down. He told the officer, I ducked, I didn't see it well. And then the officer asked for specifics, and he said, I gave him the name Torres, because that's what I have. It wasn't Mr. McKee coming forward. It was this, it was this, it was this. The testimony was, I said it was a pistol. I didn't get a good glimpse at it. The only thing I know is a Taurus, and that's what I said. I also want to talk a little bit about the search warrant for the gun.
That's not the only thing he knows.
We asked Ayden Tate if they found any casing. So what we would need is to prove that that gun would be the gun that was used in this crime. And there's no casings to compare to a gun. So this is Washington County, and many of us have cabinets full of guns. So you have to prove which gun would have been a part of this crime. And they didn't have that because they didn't have casings. And their main witness said, I didn't get a good glimpse at the gun. Additionally, they complained that there was no residue on Mr. Mills' hands. But in order to test residue, guess what you need? You need hands. They called Mr. Mills. They knocked on his door. They couldn't find him. You can't test for residue if you don't have the hands to swipe him down. They also asked, why weren't other neighbors consulted? If you saw the video,
don't we all?
It's rule. There's not many other neighbors.
I need more cabinets.
The final thing we can agree on is that the defendant does have a gun. And how do we know he has a gun? When he was arrested, he had a gun on him, and it was a revolver. And what do we know about revolvers? They don't leave casings. Those are the things we can agree on. Let's get into kind of the play of the day. We know on April 7th, 2025, the inspection happens. We know DEP says, hey, we're not doing anything about this. And then within minutes, this argument of the dog happens. You're going to find out, gun comes out, shots are fired, and 911 is called. And why do we know that was only minutes? The reason we know is because mom was on the phone with him and provided phone records for the phone call. So how did this day get this way? Well, before the DEP showed up, the defendant was hopeful. He was hopeful the DEP was going to do something. He had a complaint and he wanted it resolved. The complaint was pending. Now, what changed? After the DEP left, the complaint was rejected. And we know that these parties have a history of issues with each other. And they tell him, hey, nothing's wrong, nothing's going to be done. We know, so he's at an agitated state. Now we know the dog is running around and he's trying to find his dog. And Mr. McKee says, kind of at the end, the defendant's getting angry. But one other thing that kind of came up that wasn't really mentioned is the defendant is referring to David as John. And why is that important? Well, John is who he has the beef with. That's his father. So there's an element of being flustered. We're getting the wrong name. We can't find the dog. The DEP didn't tell us what we wanted to tell us. Anybody would be flustered at that moment. And the next thing we know, the dog, Mr. McKee tells the defendant, hey, the dog's over here. And they have this back and forth about the dog, and the words, you're gonna find out, come out. And what does that mean? It doesn't mean I'm going inside. It doesn't mean I'm calling my lawyer. It means something is about to happen. And then it did. Words became action. You're gonna find out. The gun comes out. Remember, David McKee ducks and shot. That's it. I want to talk a little bit about the scene because that was a big element there. Look, Dan Estes is doing his job. I get it. And I'm not going to fault him for doing his job, but there's a couple things he didn't account for in his job. Now, first of all, remember, we get this information that from the defendant that he was standing in front of this Cadillac, but that's not what the evidence is. Because remember, David McKee says the defendant is walking the property and he's trying to get his dog. Why is that important? Why is the fact that he's not standing in front of this Cadillac, he's walking the property? Why is that important? Because that's how the fight starts. The dog, he's trying to get the dog, right? So these photos are taken from the vantage point that he's standing in front of a Cadillac. There's no evidence that he was standing. There's evidence that he was looking for that dog. He wanted to get the dog. And we even heard he got the dog and took the dog for a walk afterwards. The evidence is the defendant wanted it to get his dog back. McKee tells you, and this is how it all begins. McKee yells at him, hey, your dog's over here. And that, we see it on the video, the white car where he's standing, that's where he tells Mr. Mills, hey, your dog's over here. And that's where the fight starts. Mr. Mills would have had to come to Mr. McKee to get his dog because Mr. McKee is the one telling him the dog is over here. The other thing that this doesn't take into account for is the fact that these men had a conversation. Both sides agree to that. Remember, Mr. McKee says, hey, your dog's over here. We fight about the dog and grandma. And then it's, hey, you're going to find out. Now, in cross-examination, the defense suggested that Mills actually said, you hurt my dog and you will find out. But both parties agreed that these men were having a conversation or an argument. I'll give you an argument. And you can't do that from 130, 150 feet. They had to have been closer for this fight to happen. And we know this fight happened because the dog initiated it. And we know that he got the dog at the end. So that doesn't take into account for these men screaming 150. This couldn't have gone on that way. Additionally, we know it happened that way too because mom's on the phone and she's hearing the conversation. She doesn't report that he's screaming, but she can hear what her son is saying. She can hear the pauses, and then she can hear the shot, right? I suggest they were a lot closer to each other, and I suggest that's exactly what the evidence shows. One peculiar thing that wasn't mentioned in trial, but you're going to hear something that David McKee said that I thought was very peculiar. He says, he testifies, and I think it's in the 911 call, that after he says, hey, David, or hey, Lee, you shot at me, Lee says what? I was shooting at my dog. Isn't that a bizarre thing to say? That's essentially David giving this defendant his defense. And I submit to you that the defendant did say that because he had realized he had actually just shot the gun and realized he had made a mistake. He had shot the gun. But we know he wasn't shooting at his dog. We know Pete is a beloved dog of the defendant. We just know that that David, when he said, I was shooting at my dog, he didn't make that up. I think it shows reflection on the part of the defendant that he realized, oh crap, I shot this weapon, I know what I've done. Let's talk a little bit about David's testimony. There's some parts about, the defense said that David's testimony is very complicated. Well, a lot of his testimony showed up on that 911 call. He's on the phone while it's happening and he's trying to figure out where to go. Do I go to my mom's? Do I go to the neighbors? Where do I go? So he immediately calls 911. And the 911 call corresponds with what mom said in her phone records is, he was on the phone with me, hangs up, I call 911. It happens within minutes. There's no time to invent a story. The deputies respond and he shows them exactly where it happened. And then they talk to the neighbor and the neighbor hears a shot. So all of that combines. So you look at the evidence shows that he ended up at the neighbor's house. The mom says, he said the things he said. The neighbor said, I did hear that shot. I didn't really think much of it. It was not that big of a deal until David showed up and I thought, oh, wow, something's happened. Let's talk about the fear. Aggravated assault is not attempted murder, and we're not accusing the defendant of that. But the question is did David reasonably fear imminent violence? He did, because he tells us he ducked. That's why he didn't see the gun very well. And he ducked behind the car door. He immediately yelled, you shot at me. He immediately called 911. He immediately left. He immediately talked to law enforcement. And those are not actions of someone who's pretending or someone who is so involved in their parents' dispute to make something up. And his statement is corroborated by the neighbor, by the mother, and by the timing of all of this. I submit to you, the defendant had a bad day. I submit he'd been having troubles. I think he'd been having troubles with his neighbors. The dog was causing issues that morning. It was a bad day. And the day got worse and his temper got worse and he made a bad decision. He was angry. He warned David, you're gonna find out. He reached for a gun and he fired. David ducked, got away, called 911, and he showed the deputies exactly where it happened and where everything was unfolding. The defendant's explanation that he was somehow shooting at his own dog in that moment doesn't fit or make common sense. The sense it makes to me is he realized after he shot the weapon, oh man, this was a mistake. The evidence all points in one direction. He said, you're gonna find out the shot was fired. And the evidence shows that Walter Lee Mills is guilty of aggravated assault with a deadly weapon.
Ladies and gentlemen, these are some general rules that apply to your deliberations.
OG Boy Mama
You must
times
follow
3.
these rules in order to return a lawful verdict.
Thank you very much.
First, you must follow the law set out in these jury instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case, and all of us are depending on you to do as much and make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of witnesses and have been entered into evidence in the form of exhibits and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's responsibility to determine a proper sentence if you find the defendant guilty. Whatever your verdict, it must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or did that made you think I preferred one verdict over the other. You may find the defendant guilty as charged, or you may find the defendant guilty of any such lesser included offense as the evidence may justify, or you may find the defendant not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proved beyond a reasonable doubt. If you find that no offense has been proven, then, of course, your verdict must be not guilty. The verdict must be unanimous. Again, each of you must agree on the same verdict. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It reads in the Circuit Court of 14th Judicial Circuit in the state of Florida, in and for Washington County, state of Florida versus Walter Lee Mills.
We have a poll up.
The jury finds as follows. Defendant Walter Lee Mills in this case, and you should select only one. The first option is the defendant is guilty of aggravated assault with a deadly weapon. Or you can consider a lesser included offense. 2, the defendant is guilty of improper exhibition of a firearm. 3, another lesser included offense, the defendant is guilty of assault. The final option, the defendant is not guilty. So say we all, and it should be dated today, the 24th day of July, 2026, and it will be signed by the foreperson.
So 2 lesser includeds and a
in just a
not
few
guilty
minutes,
option.
You will be taken to the jury room by the bailiff to begin your deliberations. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when you all have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only when one another and only when all jurors are present. If a juror goes to the restroom, the deliberations should stop until that juror returns. You are not to communicate with anyone outside the jury room about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone or any other electronic communication, such as email or any other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given you throughout this trial, please let me know by giving a note to the bailiff. Many of you have cell phones. Those cell phones must remain here in the courtroom during your deliberations.
We'll be going through
If you
them.
need to communicate with me, send a note through the bailiff. If you have voted, please do not disclose your vote. If you have a question, I will talk to the lawyers before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any question if I can in writing or orally here in open court. During trial, items were received into evidence as exhibits. You may examine whatever exhibit you think will help you in your deliberations. If you choose to see any exhibits, please request to do so in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the law, you must apply it and you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has a right to disregard the laws we all share. Thank you for your consideration. You may now retire to begin your deliberations.
Who's Mr. I wrote Mills and Wells instead of Mills. Well, all you guys are convicting Mr. Wells. He's not even on trial. I'm just kidding. That was my mistake. You know what I mean. Buy Pete some treats. Thank you, Miss Mary. Appreciate that.
Thank you, and please be seated. The jury has exited the courtroom. Counsel, Mr. Mills, any objection to the instructions as read?
No, sir.
All right. Then
Old-time
Mr. Mills,
gamer, thank you very much
sir,
for the
any
super sticker.
thing you want me to consider, anything you want to bring to my attention, any complaints?
Not at this time, no.
Are you satisfied with Mr. Morris's representation of you, sir?
Absolutely.
Is there anything you wanted Mr. Morris to do that he did not do?
No.
Any complaints you have at this time?
No, sir.
All right, so unless there's anything else, counsel, we'll stand in recess until we hear from the jury.
All right. Judge is out of here. Prosecutor heads to the door.
Cigarette time.
Somebody said cigarette time. Is that? Yeah, nervous wait right now. Where's Pete? Bring Pete in. I think the jury deserves to see Pete. It's mentioned like 70 times. So, Melissa, Chris, thank you very much for the turtle. Hydration reminder. And thanks for the buy Pete some treats. If we can find Pete. Mr. Wells is catching strays. I'm ending the poll because I put the wrong name in there. But did the state prove Mr. Mills, not Wells, guilty? I'm going to say 43% of you say yes. Only Pete knows comes in at 41%, and no at 16%. That's with the 88 votes. Sorry, I messed up the wording on that one. I think spell check corrected me. There's a cane in use. Yes, the defendant has a cane. Not sure if he had a cane at the time of this event, but he has one now. I would not be surprised either way this goes. And the reason why, and I think it's good evidence that the state brought out, is the little random facts that somebody included, that the son included, like he was calling me by my dad's name. That's weird. That's a random thing that I don't think somebody who was trying to stage this or make up a story would have included in the moment. There's just little tiny things that I realize he's got an issue with the gun. It didn't happen. I don't know if the gunshot happened. Craig, the guy down the street, was it Craig Smith? The guy with the shop, the friend of the son, said, I heard a gunshot, didn't think anything of it until, he came around. So that gives some credence to it. But I don't know if that's enough. Especially where he says where he was, all the trees, everything else, the pictures. It looks like there's a lot of trees, a lot of foliage. It is Foliage Friday, so his mom heard it on the phone. Not sure what to think about the mom. I think I could see a guilty. I could see a guilty happening here. I'm surprised the defense didn't point out that the officer testified, and if you listen carefully, I think it was Mr. Tate testified that when they arrested, or it was the other guy, when they arrested Mr. Mills, he had a revolver in his pocket, and they checked it, and he said, and made sure it was empty. Now, that doesn't mean they unloaded it. They might have checked it, and it was an empty firearm, meaning it was not loaded. If Mr. Mills is in the habit of carrying an unloaded firearm, first of all, it's stupid. If you're going to carry a firearm, they recommend you carry the full firearm, not the full Monty, but they recommend that you either do or you don't have means to defend yourself. And carrying something that appears to be a deadly weapon, but not having the means to follow through with that is not a good idea. Still stuck on Taurus? Yeah, that's very specific. That's a brand. That's a knockoff brand even. Okay, Taurus copies the Beretta 92FS. The 9mm Taurus is the same gun, just a little bit different. It's tiny differences. They copy other brands. So for him to say it was a Taurus, not a Beretta 92F, which is the 9mm version of the Taurus, the original. Yeah, he would have had to have a really good look at it, or he just made something up. I think Full Monty means something else. It might. Purple Coconut. We're not going to go there right now. Unloaded firearm is a death trap for yourself. Yes, it's escalating something and with no means to resolve it. Taurus is a knockoff brand. It's not. They're never going to sponsor the show. In my opinion, Taurus is a subpar brand. I haven't liked them. I haven't liked the feel of the guns that I've shot that are Tauruses. I would rather go with a brand name, a Ruger, a Beretta. I've owned the Berettas, liked those, most of them. Liked the Rugers I've owned. Yeah. I started a timer. I've got a timer going. As a matter of fact, I'll see if I can get it on the screen for you even. Because I am just that good. We're going to take the 69 down for Pete. Don't need him anymore. And we'll put the timer back up. Let's see. Let's see what we got. That's really small. We're going to embiggen. Box 1. Chop the top, chop the left, just a wee bit, and we'll move it to the right so you don't see all the thousands. Oh, that's up. Move it to the other right. There we go. About 7 minutes on the clock so far, and we're going to sit here and wait, and hopefully they'll keep the live stream going, and we'll get just a quick verdict on this one. Wow, that was terrible placement. Who built this? There we go. That's a little better. My OCD's kicking in. Needs to be a little neater. Courts are at lunch. 2.5 hours. Oh, we need a poll on that as well. Let's do a quick poll on the deliberation time. Have we ever had as many verdict musics as we would potentially have this week? It's a lot. 4 is a lot. Did we have 5? Was there one earlier this week? Okay. How long will the jury deliberate? Did I spell that right? I'm going to do the under 30 minutes because one of these days that is going to be what happens. So less than 30 min. 30 to 60 minutes. Add option plus 1 hour. And add another option. There's the last one. Okay, poll is up. You've got your 4 options available for you. Read carefully before you vote because you might like one of the other answers later on. Wonder how long yesterday's verdict took. I imagine it wasn't very long. I think it was probably quick. Was yesterday's verdict a hat trick or record? It was. 3 in 1 day. It's fantastic. Just make sure I'm on the right page for verdict music. Okay, we're ready. It's all queued up. 911 was the time there for a second. The defendant, who's obviously out on bond, has stepped outside for a little inhalation of smoke to calm his nerves. I think he did it. I guess it's late of me to say this, but I think he did. I'm leaning towards he did it. I'm glad I'm not on the jury because I don't think the state proved he did it, especially because you've got the whole I wasn't looking, I was too busy ducking down, but I know he shot at me. Really? Anyway, they do have lessers to consider, and they have to pick a leader, Tai Chi. They've got to do both. So you were right. They didn't prove this beyond reasonable for me because I still want justice for Pete. Wish the officer did more diligence in both the trials we saw. Yeah, that was the other comment that seems to give the state's argument validity is the random. I wasn't shooting at you. I was shooting at Pete. I don't think that's something the defendant would just dream up, or the victim would just dream up. He said he was shooting at his dog, not him, not me. Look at my last comment. This will be the 5th verdict of the week. We had one in Texas, beans, then for stick up, then wrong house, and now this one. 1, 2, 3. Does that make 4? Texas was beans. Oh, 2 for stick up. That's right, 2 for stick up. That would be the 5th. Okay, you're right. New record, new world record. We're going to stick with this in case the jury comes back in like 20 seconds. How's everybody's weekend shaping up? Is the weather treating you horribly? Oh, my cousin over in Norway. I just posted on Facebook, and Facebook, have you noticed this? They'll translate for you. Since my cousin's Norwegian. His name is Martin, just like my grandpa. Well, not my grandpa, well, who I thought my grandpa was. So I guess I'm not related to him at all. Well, I guess I'm like a quarter related to him when I thought it was half. But anyway, he posted, and Facebook comes up with this translation for his post. Very curious cow, well water, lots of field strawberries, dead viper, squeezed frog and the tranquility of the forest. Everybody lost and one in idiot. With the kids on a trip to Jorgenheide. Jorgenheide. But I don't know what the rest of it meant about the cow, the well water, and the idiot. But I think he's actually with his kids. I think I'm going to like it. I'm going to like that post. Way to go, Martin. All right. Yeah, some things just don't translate, you know. Do mushrooms grow in Norway? I don't know. I think they do. When I was there, I was just a little kid. We were there. I was there for like 11 weeks, which now seems like a long time to go on vacation. But I was there for, I think, 11 weeks. One of them, I had chicken pox, which sucked. But we were just every day, we were heading down to the beach. And we watched the Petra vessel, the ferry, come in and play in the waves in the ocean, and just it was a blast. But to give you an idea of how long ago it was, the neighbor kid who was a little older than me, was really cool. His name was Paul, and he'd take us with when he would go diving for spearfishing fish. Like he'd made a little spear with a spring on his arm. He'd like shoot out with a surgical tubing, and he'd like hand spear fish in the lake. And he'd let us go with and watch him. But he was really into break dancing, which was what was popular at the time. That's how long ago it was. All right, just doing a quick check on everything else. Close this down. To open this. It's not what I meant to type. Oh. A judge just walked in and gave us a heart attack. Came and grabbed his notes, then left again. Breakdancing is an Olympic sport with mixed results. Judge needed laptop. Okay. North Carolina SBI, North Carolina State Bureau of Investigation, was proud to participate in the 2026 North Carolina Internal Affairs Investigators Association Annual Training Conference. That's a mouthful. Held this week at Carolina Beach, North Carolina. Of course, they went to the beach. During today's leadership session, Chip Hawley, Brent Culbertson, Special Agent in Charge N. Deming, presented on the importance of service in law enforcement. Okay. And the SBI's role in assisting agencies with complex and sensitive public corruption investigations. Oh, good. Because North Carolina has a few of those to handle. Nice. That's good news. News also out from the SBI today. Winston-Salem State Correctional Law Enforcement officers are searching for offender Raymond Warren, who escaped this morning from Forsyth Correctional Center in Winston-Salem. He's 35, serving a 5-year sentence for 2 counts of larceny, and was due for release in 2028. Oh, good. White male, numerous tattoos on his neck and face. That'll help him hide. Stands 5'4" tall, weighs about 160 pounds. He's from Davidson County. Anyone should call the police if you see him. I'm holding out for a reward. All right. Laura says, my frustration with YouTube has reached a peak today. New high score. Laura, tell us more. Ooh, defendant just came back in. Popped a squat there in the chair. Everyone is chillaxing. Did that just happen? Yeah, he only had 2 years left out of a 5-year sentence. And now if he gets cut, he has a lot more years in. Can we watch the start of the day, the full hearing for this case? We did this morning. All that was televised, I believe. We can go back and watch a little bit of... where did I put that? I think it was Thurston, Washington. They had a civil case. It's sort of funny. It's not really interesting. I just think it's funny because the one party basically showed up with nothing but hopes and dreams as far as their case went. It was a civil dispute where a couple had signed a lease to rent an apartment or a home, and they showed up and they're like, don't like it, and just gave the keys back to the landlord. And the landlord's like, you've signed a lease. You're supposed to be here for 3 months. And they're like, yeah, it's a little dated. It's a little dated. Just didn't get the feel for what we wanted, so we're leaving. And then they expected the judge to not make them pay the $10,000 they owed for 3 months of rent, because it was like $3,500 a month in rent, which is a lot more than we charge here in these parts. But there we go. Anyway, the judge basically threw the book at them, figuratively speaking, saying, I just have to follow the law here, and you signed a contract. So, what's the max that he can get if guilty? We're in Florida, so we'd have to look up Florida aggravated assault, and I believe there could be a I didn't hear a deadly weapon modifier. Mr. Mills loses the jacket. Reveals that he's packing. No, just kidding. He's not. Don't. Usually you don't carry to the courthouse. It's a whole new level of entitlement. The thing is, I would expect that from a younger generation. We see that a lot now, right? Where a younger generation comes in and they have an expectation that the world owes them a favor and they've been wronged, and however they view the world is correct and it should be righted accordingly. This was like a retired couple. They still work. They work from home, but they're in the prime of their life, right? Well beyond the we've got kids at home stage, and them showing up and just being like, I didn't feel the vibe after we leased the place and got the keys and everything, showed up and looked at it. We're like, no, I'm not even going to stay here. Not even a night, and they didn't turn over the keys until they found another place to buy. They found a place and bought it, and then they turned over the keys. So they had the keys for a while, for a few weeks. And they're like, well, we didn't sleep in it one night, so we shouldn't pay. Like, that's not how it works. The landlord did not re-rent, did not mitigate losses, had no duty to. So, you heard deadly weapon? If there's deadly weapon, that's a modifier that could enhance the penalty in this case here in Florida for sure. The aggravated is the deadly weapon thing. That's the aggravated one. That could add 5 to 10 years. Kids these days all want an Instagram-ready place as a starter home. Speaking of Instagram, I've never got into... I posted one picture on Instagram, other than my 3 trees. I've done my 3 trees on Instagram, but other than that, I've only done one like real picture on Instagram, and it was amazing. It was the sunrise over a wheat field in a marsh, like next to a marsh. And it's just the dew on the wheat and the sun, the rays of sunlight. It looks like there's a filter. There was no filter. Since then, I've not found a single good picture to post. But I am thinking about. They've got a note. I'm thinking about starting a Pinterest.
You have a verdict or a question?
Question.
Okay.
You have a question. 22 minutes in. Waiting for the state.
Excuse me, not a question, a request.
Can we get some lunch in here? Can you turn the air down a little bit? I'm sweating bullets. Maybe this request will give us a clue as to what they're doing. I'm thinking Pinterest. I'm going to start pinning things. It's going to be a faceless Pinterest account. It's not going to be called RA. You'll never be able to find it.
So Judge Collier, when you are in Chipley, where is your favorite place to go to lunch?
You're on the record,
I'm
Judge.
taking notes. Beefs?
No, there's that, Rails place across the street?
Oh, yeah?
What is it called, Rails?
Yeah, it's the buffet place.
Yeah, and then there's a deli right across the street from it.
Oh.
So those are the only 2 places I've been. I usually don't eat.
The deli place is called Slaska.
Rails, railroads, something.
Yeah, fair enough.
I usually just walk around Walmart.
There's always a Walmart. Okay,
All
here
right,
we
we're
go.
back on the record. And we have a request from the jurors. It reads, we would like to see all the photos, please. Signed, Cindy Chrysler. Here you are.
We want all the photos. They want to see.
I don't think there needs to be a written response or
the
anything back
shrubbery.
in. We just send the photographs back. Do we have all the photos from the state and defense?
I put in that one, but I don't have it.
Don't miss the forest for the trees.
How did you not have the photos ready for the jury?
We have a 911 call, a video, and yeah, Exhibit 3 is the photograph from the state.
They want the 4 dog pictures. They asked for everything, but they really just want to see the dog. Like, we would like to do a site visit and see Pete.
Miranda, if I email it to you, could you print it off?
Come on, prosecutor. That's lazy. How did you get them admitted into the trial without a printed out copy?
All right, so we're in agreement. We're going to send back all the photographs, including Exhibit 3 from the state. Is there anything else we need to discuss? All right, we'll send those photographs back, and we'll go off the record and wait until we hear from the jury.
All right, 3 minutes later, we decide they get the pictures. Ruth's
The still shot, Megan, that you took from the video. What was that again? What was that image of?
The truck.
The video, just where they had parked and moved away.
Yes, there was a guilty in the wrong house, or not guilty in the wrong house trial. He was acquitted. Judge reminds me of Leslie Odom Jr. Who is that? Is that the Saturday Night Live? Is he a comedian?
Yeah.
I played the drums in middle and high school. I wasn't in the band, but I was.
Hang on, it's coming.
I played the drums. I wasn't in the band. I just played on the drums. Lindsay Ross gifted a membership, and it went to Alex, the Dane mom. Congratulations, Alex, and thank you,
You wear
Lindsay.
multiple hats, sir.
Yes, the band camp stories are starting now. Good thing we muted it. I don't know actors' names. Alex, the Dane mom. Who's the guy that in the skit where they're talking about our forefathers? It's like, and we will use the metric system, or we'll use the metric system, but only in this and that, and the rest we'll use. We'll use yards and miles, and that skit. Where is Mrs. Mills? Not supporting husband. We don't have any testimony that he's married. He might be a bachelor. I can never watch trials anymore or participate in chats. Candace. Sorry, that's Kenan Thompson. The reason why I say that is because his smile reminds me of Kenan Thompson's smile. That little subtle, it's like a little bit of a grin that he can't contain. And occasionally you'll see that from the judge. Loves True Crimes. Thanks for 5 gifted memberships. Not surprised at all if he's a bachelor. I don't know. Maybe he's retired. Who's the lady next to him? It's got to be a lawyer, because you can't be up past the bar without, unless you're the defendant or a lawyer or paralegal or something. Sometimes paralegals get to sit up there. So it must be a legal assistant. But she's, like, off to the side. She's back. We've printed things. She printed it. Those are the pictures? She printed them this big? At least we got full page pictures of the dog. Retired from marriage? It's not the terminology they normally use. Did they see the rental beforehand? Yes, but when they got there in person, you're talking about the Tumwater, Washington case. When they got there in person, they just didn't like the vibe. And they were like, and one of the chairs had a tear in it. The judge is like, well, is there any evidence, any reason you can give me why you would not be liable for the full contract? No. We didn't stay there. It was crazy. And when we remember what state's picks are, state's picks, we had the police officer truck coming towards us, that screenshot. And one other. I think it was looking back towards the house. I don't know, but maybe it was the defense that brought all the pictures about that. I think it helps because the defense introduced a lot of pictures. So if the jury wants to hear from the defense, it's possible they're leaning that direction or wants to see the defense's evidence. Britta, welcome. Good to have you here. Let's take a quick peek around because we can. See in the world of true crime exactly what's going on. All right, Judge Simpson, I think he's still doing landlord-tenant stuff. Yes, he is. We try not to do those. Halibut fishing, more fishing. Expedited calendars out of Georgia. Inflatable boats. What's how stuff works. More fishing, more fishing. Got the crazy guy on the bridge. A lot more fishing. Judge Webster is in break. Never mind. Could go to Kansas. Got 14th Circuit. No Judge Boyd. No McNally. It's definitely a Friday. It's awfully quiet. Judge DeSanto. Judge DeSanto. She's 27th District, right? All right, let's jump in there and see what's happening for a second.
Let's go off the record for a moment. I just need to keep this here. You didn't bring copies?
I'm gonna take.
So, Judge, I do bring copies. It's just I just wanted to copy it for the same mark.
What?
I just wanted a copy with the stamp, word stamp on it. That's okay. Because I'm gonna upload it to my system at some point.
Okay.
Judge's like, okay, whatever. Oh, this is the one where we get to see the bailiff searching Pinterest or Tinder or whatever he does, right? Yeah, he just scrolls around for a while. Okay, let's see. What else can you see? What's underneath me? Oh, nothing. It's just the judge's desk. We have audio turned on from our 14th Circuit Court, so if anything happens there, we'll bring it to you as soon as it comes in, so we're not going to miss the verdict on this one. Famous last words. You've got mail. Says we need to rewind a little bit on this one. So let's scroll back and see if we can find the video. And we have found video. Okay. Yeah, we're just waiting for the judge to come in, and now she's not on the bench yet. This looks like a police wall of the lobby, police department, 6/6/2006. This was last month. Security camera footage from the police department west wall of lobby. I think we're all queued up. Let's skip ahead just a tiny bit. See if the judge comes in. Can somebody tell us what this is that we're waiting to watch?
Have to do with that.
Oh. Back up.
And
Are in the courtroom that
Trying to find where the judge comes in.
Officer Simoniak and
Yeah, we're sort of picking this up blind, so let's see what this is.
okay, the court has reviewed People's Exhibits 1, 2, and 3. And are the people calling any witnesses?
yes, one.
You may call your first witness. Let me just ask this other question. Are there any other witnesses in the courtroom that will be testifying as it relates to the bond violation?
Yes.
Some of us are. For the people.
Your Honor, since the defendant stipulated to that being him in the video, there will be only one witness called for purposes of the bond violation, and that is Detective Michael Murphy from the Southgate Police Department.
Okay, so my question still stands. Are there any witnesses in the courtroom that the people may be wanting to call as a witness for the bond violation? Or even in the preliminary examination that could be affected by any testimony here today?
Detective Klanowski is associated with the bond violation. However, I will not be calling him to the stand, but I'll ask him to exit the courtroom.
Okay.
And Officer, I'm sorry, how do I pronounce your name? Officer Simoniak from the Southgate Police Department is also associated with the bond violation. However, I will not be calling him to the stand, but I will ask him to exit the courtroom as well.
Okay, thank you. Yeah, I'm sorry, can you please spell the last name of the officer?
Yes, Simoniak is spelled F as in Sam.
I'm sorry, just a moment. Just so you know, your microphone's on, counsel, there, and so it's affecting the record, just so you're aware.
Your Honor,
No, it goes right into your ear when you touch it. Okay, I'm
Quit
sorry.
touching it.
Thank you. The officer's last name is spelled S as in Sam, Z as in zebra, Y M O I M O N I A K. And I'll repeat that just for clarification.
QSTH.
SZYMONIAK.
Good thing I had
The
you
K is
spell it. I don't
silent.
think Alicia would have gotten that. Okay. All right. And so the court will ask you to please step out for purposes of testimony. And Ms. Longstreet, are there any witnesses for the defense that are in the courtroom that could testify in this matter?
Samuel Sale.
Can you please step out and okay. All right, and then there's one other individual in the courtroom, but she's not expected to testify, is that correct?
That is correct.
Okay, all right, and so counsel?
Yes, for our first witness, Your Honor, the people call Detective Michael Murphy from the Southgate Police Department.
And Alicia, the person in the waiting room is a Southgate detective, so I'm going to do an arrangement. All right, please raise your right hand. You solemnly swear or affirm testimony about giving this matter be the truth, the whole truth, and nothing but the truth.
I do, Your Honor.
All right, thank you. Please have a seat. You may adjust the microphone and please state and spell your first and last names for the record.
First name is Michael, Michael. Last name Murphy, Murphy.
What's the name of my guitar
All right, thank you.
teacher
Counsel,
in high
you may
school?
proceed.
Thank you. Detective, are you currently employed?
Yes, sir.
And how are you employed?
I am a detective sergeant with the Southgate Police Department.
And were you employed in that capacity as a detective with the Southgate Police Department on June 23rd, 2026?
Yes, sir.
And on or about that time, did this specific case come to your attention at some point?
Yes, sir.
And how did that begin?
On June 23rd of this year, I learned that our Southgate Police Department Records Office received a copy of a pistol purchase permit was mailed to them by CC Coins and Pawn out of Wyandotte. That copy of the pistol purchase permit showed that Mr. Salem purchased a AR-15 pistol from CC Coins and Pawn on May 19th of this year. An issue with that pistol purchase permit, it has an individual license number affiliated with that, and that license number had already been used for another pistol purchase permit for Mr. Salem on May 19th as well, and that was from Supermatch Firearms Dealer. Nice. Stop there.
I'm sorry, what was the name of the CC what?
Coins and Pawn here in Wyandotte.
Okay.
Three minutes, yeah.
We're waiting for this screen to be played or go back on full screen. We're on Verdict Watch with...
Your Honor, may I approach the witness?
You may.
Thank you.
Let's see where we were on 7. Let me put that on.
Detective, I've handed you what's been introduced in the evidence as People's Exhibit 1, 2, and 3. I'd like you to take an opportunity and review those 3 exhibits.
Yes, sir.
Have you reviewed those 3 exhibits?
Yes, sir.
Do you recognize those 3 exhibits?
Do.
And how do you recognize them?
Exhibit number 2 was the copy of the pistol purchase permit I became aware of on June 23rd for the AR-15 pistol from CC Coins and Pawn. Exhibit number 3 is a copy of a pistol purchase permit I just noted from Supermatch, in which the Sig Sauer was purchased in Mr. Salem's name also on May 19th. And exhibit number 1 is an invoice for that pistol purchase permit for the Sig from Supermatch.
And did something about those 3 exhibits, and is that a fair and accurate depiction of what you observed previously?
It is, sir.
Does it appear to be altered or manipulated in any way?
It does not.
And what about those 3 exhibits drew concern, if any?
As mentioned, the license number on each of the pistol purchase permits is the same. It's supposed to be for one single purchase of the pistol.
And can you provide some background to the court of why that drew concern? How does it typically work?
I'm gonna ask, what's the relevance? We're getting into the fact that he said he purchased multiple guns. This is a violation here.
The relevance, counsel?
Well, Judge, I guess my concern at this point is if the defendant is using duplicative purchase permit. So when you get a purchase permit, you get it with one license number. How, I guess, it's had the same license number is being used to purchase multiple weapons.
What does that have to do with the guy?
So if there's been some sort of a copy of a purchase permit when it was blank, and now you're using that same purchase permit to purchase.
Okay, but counsel,
What's the
how does
relevance?
that, if the bond violation is that Mr. Salem was in possession of a gun, contrary to the court's bond order, what does the license or multiple licenses or possible multiple licenses have to do with that? Mr. Salem's, there's been stipulation that he brought the gun in there and that, that is him on the video. He stipulated to the make and model of the gun and serial number. So I'm not sure how the licenses are relevant for purposes of the bond violation, the multiple licenses. I can see that the date would be significant, but it doesn't appear as though the balance of what this testimony is at this point for this issue is relevant. So the court's going to sustain the objection.
Understood, thank you. Sir, what did you do next? How did you further your investigation?
I opened an investigation following up on what was believed to be the fraudulent use of a pistol purchase permit. To provide a calendar timeline of events with that subsequent investigation, on April 23rd of this year, Mr. Salem obtained a valid pistol purchase permit from the Southgate Records Office that would be good for 30 days. On May 7th would be the date of this year that Mr. Salem was arrested by the Wyandotte Police Department for CCW of a pistol. On May 8th, that following day, he was arraigned and given the conditional bond not to possess firearms or weapons. Next date coming into play would be May 19th, which would be the date each of two pistols were purchased and confirmed at two different firearms dealers. One being the 6 Sauer from Supermatch, which was confirmed by our records office in Southgate, both over the phone and sent by email, which would be this invoice, which is exhibit number 1. The second pistol purchase permit, the AR-15 purchased by CC Coins and by Mr. Salem at CC Coins and Palm, I confirmed over the phone with CC Coins employee Brandon Donaldson. On May 22nd, learned in my investigation, our Southgate Police Department Records Office also received an NCIC notification that Mr. Salem had been denied purchase of a long gun.
Judge, again, what is the relevance of attempted purchases? I mean, I assume this is the officer of Southgate. I think the dates are relevant, but all these additional details?
Well, you're correct. This is the officer from Southgate as stated in the second question.
You got that correct.
And what is the relevance to that date of, I'm sorry, you said May 22nd?
Seriously. Talking to her about words. You gotta just told to come on up. Yes.
They have a decision?
Yes.
For Pete's sake, the jury has finally reached a conclusion in this case of beware the dog. Beware the dog. Neighbor dispute over a dog and a couple other things like dirt turned into what could have been a deadly encounter as the son of the neighbor approached the neighbor about the dog. Says that the neighbor pulled out a gun and fired it.
Go back on the record. So by the bailiff that we have a verdict. Anything?
The verdict took
before we bring the jury, counsel?
48 minutes.
Yep. All right, sir.
Jury's coming in. Obviously, this looks clear cut. The speed of this seems to indicate to me that the prosecutor's about to take her second consecutive loss on aggravated assault. That was too quick. That was too quick, I think. What do you guys think? Did the state prove it? I'm not sure if I'd even ended the poll. hadn't. I'm going to end the poll now. Hold on.
Thank you. Please be seated. The jury, I'm told that you have reached a unanimous decision in this case. Clerk, would you please pass the verdict form to the bailiff?
Passing it up. Let me end the poll, please. End poll. There we go. All right. Let's see. 30 to 60 minutes. 50% of you were right. Nailed it on the time.
Verdict
Congratulations.
form is in order. If you will please rise with your attorney, and the clerk will publish the verdict.
In the Circuit Court, 14th Judicial Circuit of the State of Florida in and for Washington County, State of Florida versus Walter Lee Mills, defendant, case number 25-118 CF. We, the jury, find as follows: defendant Walter Lee Mills in this case, the defendant is not guilty. So say we all, dated this 24th day of July 2026, signed for foreperson.
All right, thank you. Please be seated. Ladies and gentlemen, I wish to thank you for your time and your consideration in this case, and also advise you of some very special and unique privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for thousands of years that a jury's deliberations, discussions, and votes must remain their private affairs so long as they wish. Therefore, the law gives you a unique privilege not to speak about your work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are curious, from those who may seek to find fault with you, or from the media, or from anywhere else. It will be up to you whether to preserve your privacy as a juror. Again, on behalf of everyone here in the courtroom, I wish to thank you for your service this week. You are now discharged from your responsibilities. You can leave your jury badge there in the seats. All the prior admonitions and rules that I previously imposed are hereby vacated. You're free to talk amongst yourselves or anyone else about this case. Again, thank you. We'll all stand as you exit the courtroom and go about your personal affairs.
Thank you, Your Honor.
Prosecutor is now 0 for 2, as is witness Officer Tate. Thumbs up, smiles to the defendant as they leave.
All right, thank you. Please be seated. Mr. Mills, the jury of your peers have found you not guilty. A verdict and judgment of not guilty will be entered in this case. You are hereby discharged from all obligations of this court. Is there anything else in this case, counsel?
No,
all right,
sir.
thank you all. Have a great weekend.
Thank you.
Thank you.
They shake hands, and they go. They, what was that? Somebody was talking into the mic just for a second. They gone. Oh. I'm sorry. I had to laugh because I think these are viewed as easy cases to win. And you know the prosecutor has to head back to the office and be like, yeah, I took an L. I took an L on that one for the team. 2 in a row this week. Yeah. I don't know. It seemed like a cut and dry to me. But double L's. Double L's. She failed again. So I think she did a great job, honestly. I give her props. She's... Meanwhile, I have to go back to the other one. Let me get the other going as well. That was in 7, right?
22nd, Dave.
Mr. Salem.
No. Sorry, hold on. Not you, officer. Sorry, or detective.
I'm just gonna let it sit right there and wait for it to advance a little bit. I give her props. She tried hard. She did well. She fought well. She presented evidence well. PowerPoint not so good, but what she didn't get was the beyond reasonable doubt. She made assumptions, I think, in both arguments. She made assumptions that something that wasn't clear to me should be clear to the jury. And I think that's where they got lost a little bit. Where instead of saying, she said, one in the last case, Wish we had more evidence, you know. And I think the jury was probably saying the same thing. They're not that this didn't happen, but the state hasn't proven that it did. And when you're going to take away somebody's freedom, you need to prove it. You need to prove it. You need to bring more. How did you vote in the poll? I thought they were going to find him guilty. I sort of voted how I thought the jury was going to vote. But when they came back under an hour, I'm like, and especially the questions, asking to see the pictures that the defense brought, because the defense brought all the pictures, including the picture of the dog. I'm like, those 4 pictures of the dog go back there, and they're going like, we can't deprive this dog of his owner. So there we go. All right, we're going to jump back to this little hearing in progress, and we're going to wrap up the day with this one. So DeSantos.
Thank you, sir. And you referenced the video. Had you, prior to today's date, had an opportunity to review the video associated with the defendant turning over one of the firearms?
I briefly saw it.
Let's watch that.
You believe that if you were to observe a short portion of that, you'd be able to identify that video?
Yes, sir.
All right, roll tape.
I'd like to draw your attention to the screen. And Your Honor, actually, I believe there's a stipulation with defense counsel to admission of this video. I'd like to introduce, pursuant to stipulation with defense counsel, People's proposed exhibit number 5. I recognize I skipped a exhibit number, which would have been 4, but it's already been pre-marked for a different future exhibit.
All right, and Ms. Longstreet, is there a stipulation in the video?
Still stipulated.
Okay, thank you. And are you on your phone for this purpose, counsel?
Yes. What do you mean?
Your phone. I see you're on your cell phone. Are you on your phone for this case or something else?
Something else, sir.
Please do not do that.
Yes.
You may proceed.
Thank you, Your Honor. And just for the record, this video is labeled inside the video as PD West Wall of Lobby dash 06/06/2026. And it has a timestamp of 3/21/14.832 p.m. I'm requesting to publish at what appears to be 3 p.m. and 3:23 p.m. with 23 seconds. Publishing now.
Okay.
There's the dude. He's like, hey, I'm here to turn in a handgun. He's like, okay, what you got here?
Pausing at 3:24 p.m. and 19 seconds. Detective, are you aware of what occurred in this video?
Yes, sir.
And what did you learn after reviewing this video and as part of your investigation?
The bald is beautiful.
That on that date and time, Mr. Salem turned over the noted 6 sour in evidence over to Lieutenant Simoniak.
Thank you. No further questions from the people. Thank you.
All right, thank you. And for the defense.
Officer, you asked Lieutenant Salem to bring the gun in and surrender it?
Okay, I'm sorry. What was that, counsel?
I'm sorry. You asked Mr. Salem or someone in your department asked Mr. Salem to bring the gun in, surrender it, correct?
Detective Lieutenant Klinowski did.
Yes, and he did so.
Yes.
Promptly.
The following day.
Your Honor, I would object at this point, only because I think this goes to lack of personal knowledge. Detective Klinowski is present. He's outside the court. If defense counsel would like, I have no objection to her calling him as a witness to ask him directly as to what he said. So that's our position at this point.
He already answered.
Your response, counsel?
Judge, my response would simply be that he just testified that that was Mr. Salem turning in the gun, right?
No, when he testified, well, I'm talking about the objection to what Detective Lieutenant Klinowski asked your client. That the objection is to that question because Detective Lieutenant Klinowski is present. And Mr. Mohammed stated that his objection was that this witness may not have the proper information on that and that Detective Lieutenant Klinowski would be the best person to ask that question of. Is that your objection, counsel?
Yes, correct, Your Honor.
Okay.
Well, okay, Judge, since he answered it, can I try to lay a foundation to see if he knows and how he knows?
You may, okay, so the court's going to sustain the objection, strike the answer, I will allow you to lay a foundation.
Thank you.
Okay. Officer, did you ever have any contact with Mr. Sale?
I don't believe that I did.
And so you aren't the officer that retrieved the weapon?
Correct.
And that was Officer Legowski?
Lieutenant Simonek.
Okay, Lieutenant
Simonek is the officer for Southgate. They're taking the surrendered weapon.
Okay.
And if there's confusion with names, I apologize. Detective Lieutenant Klinowski would be another representative of our police department that's here.
Nonetheless, you know that that weapon came into possession, right?
Yes, ma'am.
And if you have personal knowledge, do you know what day that was?
The date that it was surrendered, is that what you're asking?
Yes.
June 6th of this year.
Okay. And do you know what time?
I don't know specifically.
If you refresh the court as to when this weapon was purchased?
May 19th.
Pardon me?
May 19th, 2026.
The weapon was purchased May 19th, correct?
Correct.
And was that before or after? That just 1 second. That's all.
Yes.
That I took delivery. Leaving my son back to the 19th.
Sir, you might want to speak a little bit on a lower level.
I have no more questions of this.
Okay, thank you. Any redirect?
No, thank you, Judge.
Okay, thank you very much. You may sit down, please. You're not discuss your testimony with anybody.
Thank you, Your Honor.
People have any further witnesses?
No further witnesses, thank you.
Okay, thank you. And Miss Longstreet?
So the cops tell him to turn in his guns. He does.
Judge,
They charge him with a bond violation
Mr.
for having a
Salem would
gun.
like to testify.
Okay. But I'll have you step over to the witness chair, and actually I'm gonna have you step, maybe pause for a moment. I have to do an arraignment for Southgate PD and a bedside arraignment, so we're going to take a brief break on that.
Bedside
We're going to
arraignment?
handle that matter, and then we will resume with this one. Okay?
Didn't know that was an option.
Okay, if I step out.
If you just can't get out of
And
bed in the
counsel,
morning.
if you want to have a conversation with your client in the lobby, we can certainly do that as well. Okay. Is the attorney present, and did they are to speak? Okay, Mr. Mohammed, I need you to stop screen sharing actually, let's, can you stop the screen sharing for a moment?
Lose the video so we can see the court.
Can you, however, I just need somebody to,
Unplug or something. There we go. Okay.
Judge?
yes. Perfect, okay. All right, and Detective Maroney, has the attorney logged in yet and spoken with the defendant? You're muted.
No, Your Honor. I'm waiting for him to zoom in.
Okay. Well, that's. Do you know who the attorney is, Detective?
Attorney Melito.
Defense question in blue
Okay.
dress.
Well, I guess we can take Mr. Salem's testimony while they're talking.
Supposed to look for blue dress question.
That's it.
All right, thank you. All right, and so,
Here we go.
counsel, you have called your client to testify. And so, Mr. Salem, I'm going to have you step up here to the witness base. All right, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, please have a seat, speak directly into the microphone, and state and spell your first and last names for the record, please.
I'm Ayden, J-M-A-D, last name is S-A-L-I-M.
All right, thank you. You may proceed.
Good afternoon, Mr. Salem. At some point, did you purchase, two firearms?
Yes.
The reference firearms, from court today?
Yes.
What do you need to purchase a firearm?
Purchase permit.
Okay. Did you obtain a purchase permit for those two firearms?
Yes.
These are her best
What
court
date
shoes.
did you obtain the purchase permit?
I believe it was the 23rd of April.
Okay. That would have been before your arrest, right?
Correct.
Okay. Is there an expiration date on the purchase permit?
Yes. 30 days.
So, do you have a purchase permit
Okay.
for the firearms that you purchased?
Do I have them now?
Yes.
No, they were unlawfully taken from me.
Your Honor, my apologies. I would like to excuse the two wind-out officers because at this point, because the defendant is is testifying, I think it could, some information could come out that would associate them. So in the interest of that, ask them to step out.
Okay, thank you for that.
All right,
They
thank
were
you.
unlawfully
And so the court
taken
will
from
note
you.
for the record that, both the officers, the wind down officers have, left the courtroom.
Thank you. So, you don't have the permits, but in order to legally purchase, firearms in the state of Michigan, you need a permit.
Correct.
And it expires.
You don't have a CCW
All right.
or CPL, I'm sorry.
And you obtain that permit, did you then take those permits somewhere to purchase a firearm?
Correct.
Would that be?
Hold on, let me, before we proceed, I think it's prudent of the court to advise Mr. Salem, because he is testifying in this matter, sir, that, you do realize, sir, that you do have the right to remain silent, and that anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes.
You understand that it could be used against you in your pending
this or
felony
other
matter. Do you understand that?
Yes.
Okay, I just think that it's clear that the record reflects that Mr. Salem is aware of that, and that anything he testifies to here today could be used against him for any further proceedings, possibly.
Thank you.
Okay, thank you. Are the people satisfied with that?
Yes, Your Honor.
Thank you. And Ms. Longstreet, are you satisfied?
I am, Your Honor.
I think you may proceed.
So after you, obtain those permits on April 23rd, did you then go somewhere to purchase a firearm?
Yes, there were firearms that I put on layaway.
Okay. And are those the same firearms that are the subject of today's hearing?
Yes.
Okay. Where did you go to purchase the firearms?
Supermatch, Shooting Sports, and CC and Coin.
Okay. Do you recall what day you actually purchased them?
I believe one of them was, I want to say the last week of April, maybe the 26th or the 27th, and I do know that the one from CNC Coin was the couple days prior. CNC Coin, maybe the May 1st or 2nd. I don't know the exact date.
Go stipulate.
I object. The defendant keeps using words like "I believe," and it sounds like he's speculating at this point. So based on that, I'm going to object. The legal objection is speculation. The words he's using, and he's giving multiple dates, it doesn't sound like he's sure. So I think that should be struck from the record.
Okay, your response, counsel.
Judge, I think that it's up to you to determine how you accept the testimony. He's not solid on the dates. I'm going to tie it all up.
Okay, so what I'm going to overrule the objection for right now. Mr. Salem, if you don't know the answer to something, you can state you don't know the answer. If you are unsure, state that you're unsure. Your attorney will then do whatever she needs to do to that event or to that end if she needs to lay a foundation or otherwise. But if you can't guess, that's not appropriate.
So I apologize. It just been.
No. It's not an opportunity for you to respond to the court. That's the order of the court. Next question, please.
Thank you, Judge, for that instruction.
Okay, let me ask it another way. You're sure that you obtained a permit to buy these firearms before May 8th?
Yes,
Okay, you're positive about that?
100%.
You're positive that you went to both of these stores to buy those firearms before May 8th?
Correct.
And in order to do so, you had to obtain a permit, correct?
Correct.
And you had to obtain that permit before May 8th. Is that fair to say?
Yes.
And when you went to purchase these firearms before May 8th, did you leave the store with those firearms?
No.
Okay. Are you absolutely sure that at that time you did not leave the store with those firearms?
Yes, a background check has to be run thorough since I don't have a CCW or CPL.
Carry concealed weapon.
CPL, you cannot leave with the firearm until government clears them.
Okay. And at some point, did you find out that the government cleared those firearms?
Yes, the store called me.
Okay. Was that before or after May 8th?
One of them was before, one of them was after.
And what's significant about May
That was when my bond restrictions were set.
8th? And so your bond restrictions were set on May 8th. Were you at some point released from custody?
On the 11th.
And did something happen after you got released from custody that made you go to the store where you originally purchased the firearms?
Yes.
And do you know what day that was, that you went to the store to retrieve the firearms?
The 19th.
Of
May.
May. How do you know it was May 19th?
It's a date on the purchase permit.
And when you say it's the date on the purchase permit, what do you mean by that?
The date is written when you, not when you purchase them, when you take delivery of them.
Okay. So is it fair to say that you purchased some firearms, put a deposit, and you didn't accept delivery of them until the May 19th? Is that fair to say?
I think he's in
Yes,
violation.
but I physically didn't accept possession of them, but.
So wait,
Yes.
we're gonna be there.
Okay.
So you go to the store. What prompted you to go to the firearms store on May 19th?
They called me and
Okay, let me stop you there. You can't say that. Use the name of the store.
Supermatch called me and told me that my
Still hearsay.
purchase permit was going to expire, that I needed to come and get them. I'd have to apply for a new purchase permit and start the whole process over.
Okay, because that permit that you have from 423 expires, right?
It would have, correct.
Did you go alone or with someone to Supermatch?
I went with my son to Supermatch.
Okay. And when you got to Supermatch with your son, what in fact did you do?
Made sure that my son had possession of the gun and he dropped it off at a friend of ours named Christopher Murphy.
And why did you do that?
Because I'm not allowed to have any possession of any firearm.
And was there another condition of bond with respect to firearm?
That I couldn't purchase them.
But you had, is it fair to say in your mind you had already purchased these?
These were already paid for.
Do you recall that a condition of the bond is that if you had any firearms that you were to turn them over
Correct.
to the police?
Yes.
Did you do that?
I returned the SIG, the several others that I had at the time, my attorney.
Well, I don't want to get into what
Okay.
anything your attorney said, but based on, don't tell me what the attorney said, based on what your attorney said, what did you do?
Get rid of the weapons.
When you say get rid, you don't mean you toss them in the river.
No.
Are you saying that you put them somewhere for safekeeping outside your possession?
I sold them to recuperate the bond money and attorney fees.
Okay, so you got rid of the firearms to get the money that you spent on bond back, right?
And attorney fees, yes.
Attorney fees. I'm not ready to watch this. Thank you.
Okay. Mr. Mohammed?
Thank you, Judge.
He's excited.
You were prior to that date of the weapons on May 19th, going to the store with your son, as you stated. Were you arraigned in this case?
Yes,
And were you aware of the bond condition associated with the arraignment?
yes,
And were you aware of the condition of not to possess any firearms?
correct.
And is it your representation here under oath that you are aware of all the conditions the court had imposed on that specific day?
That's exactly why I didn't possess any.
It's yes or no, sir?
Yes,
Thank you. And is it your testimony here today that on May 19th, you went to the Supermatch shooting sports store with your son to pick up the firearm, correct?
correct.
And at that time, had you obtained or been in possession of a license to purchase? A license number associated with the firearms in question?
They had, you talking about the purchase permit?
Correct.
Yes, it was with the gun store.
How many purchase permits did you have with you at the store?
I want to say about 3 or 4.
And you had an opportunity to review with your attorney present the two exhibits, People's Exhibit 3 and People's Exhibit number 2, prior to its introduction, correct?
I don't know what those exhibits are.
Your Honor, may I approach the witness?
Yes. With what are you approaching him with?
A copy of People's Exhibit number 2 and People's Exhibit number 3, and I've showed it to defense counsel.
Yes.
Thank you.
Thank you.
Sir, I'd like you to take an opportunity and review those two exhibits.
Okay.
Have you reviewed them?
Yes.
Your Honor, may I approach and recover the two exhibits?
You may.
Retrieve.
And, sir, those two exhibits were stipulated and introduced into the court today. At that time, did you review those two exhibits with your attorney present prior to its admission?
With the little time we had, correct.
Sir, would you like additional time to review the two exhibits?
You guys won't grant me another motion to.
Sir, it's yes or no, and it isn't as though the prosecution did not grant that, it's the order of the court. So the answer is yes or no.
I don't need more time.
And so is it your testimony here that you have reviewed it and there's no more, you don't need any more time to review it, correct?
No.
Okay. And did you observe any observations or writings on these exhibits that you stipulated to that were incorrect or inaccurate?
There is some hold on. Rephrase that. There is a mistake with the paperwork.
So is it your testimony here that you had observed mistakes on the paperwork but still agreed to introducing it into the record pursuant to a stipulation?
I didn't. I don't know how to answer that properly.
It's a yes or no. Is it your position that you agreed to introducing these two exhibits despite being on knowledge of mistakes from your assessment?
Yes. What's the objection?
Want to make objection. We agreed to the stipulation, whether or not mistakes on them is irrelevant. We agreed that they get admitted into evidence, not to their authenticity, not to whether they're all correct.
All right, and so your response to relevancy?
Judge, number one is cross-examination, so
I'm aware of that.
No,
I need to know what's the relevant portion
well, Judge, I'm
of that testimony.
Well, I'm attempting to impeach the witness, and so I don't want to get ahead of what I'm going towards, but Judge, on the two documents that were admitted into evidence, there is a purchase/transfer date, which is dated 5/19/2026. Additionally, it also includes a purchaser signature, which appears to have the defendant's signature. So I was trying to get to where he sees these mistakes on these documents to see.
Counsel, I appreciate that. The objection is relevance as to whether or not the mistakes are relevant to these proceedings here regarding the bond violation of Mr. Salem having possessed or had access to the firearms. How is that relevant to the bond violation?
Because this document shows a purchase date of the firearm in question that is after the, yes.
Right, that's already been stipulated to. I can review that. My question is, so the objection is, what is the relevance of whether or not Mr. Salem knew that there were mistakes on there and still stipulated for the admissions? That's the question.
I understand. Now, Judge, it goes to his credibility. So because he's taken the stand, I'm attempting to also attack his credibility because if he's now saying that there's mistakes versus earlier saying he was stipulating and saying, okay, I'm okay with introducing it. It shows a sense of credibility issues because I don't take.
I can appreciate that, counsel, but for purposes of the bond violation hearing, I don't need those exhibits to assess the credibility.
The judge has already tipped her hand as to how she's
sustain the
going to rule
objection
on
regarding
this.
the relevance.
Thank you.
Possession or
Sir,
access
you
to.
indicated on direct questioning by your counsel that you had gone to Supermatch Shooting Sports to pick up the items, correct? With your son. Is that correct?
Yes.
And on that day, you possessed the firearms with your son. Is that correct?
I did not possess them.
Okay. And so what happened when you and your son went to this? But earlier you indicated that you had gone with your son to pick up the weapons.
My son took possession of them.
And how did you and your son arrive to this Supermatch Shooting Sports store?
Different
Was it
cars.
in one
Has to be
car,
different
different
cars.
cars?
Different cars.
Different cars.
What car did you arrive in?
I don't recall.
You don't recall the vehicle that took you to the location, but you recall who you went with?
I have one vehicle. I'm not sure which one I drove that day.
How many vehicles do you have?
4?
And you're registered, and are all 4 vehicles registered to yourself?
No, not a single one.
Okay. Do you recall what type of vehicle your son went in?
Probably one of his cars.
Well, sir, you mentioned the word probably, and I'll respectfully ask you to testify to what you know, not what you think.
In one of his vehicles.
I'm sorry?
In one of his vehicles.
Do you know what vehicle your son went in?
I don't recall.
Do you know whether or not the vehicle he went in was his?
It was in his name. He has 3 vehicles.
Hold on, just one moment. There's an objection.
This line of question, if the son went there in a car that was his, or the issue is whether or not the son came with him and took the guns.
Okay, Mr. Mohammed, the objection is relevance.
Your Honor, the witness has testified to some dates in this case, and I think as Your Honor is aware, the dates associated with this case are very important. For example, the arraignment date, the date he went to the store.
I understand. How is what vehicle his son drove important? How is that relevant?
Well, again, it's the details. I think it's showing that this individual, the witness that's testifying under oath, is speculating to a large portion of what he's saying, especially the dates. He can't recall simple facts like what type of vehicle he went in.
Okay. And counsel, I will just remind you, this is a bond violation hearing, not necessarily a trial or of sorts. So I don't find that, and I can appreciate paying attention to details, but for this purpose, I don't find that that's relevant for the bond violation purposes. So the court's going to sustain the objection.
I understand. Thank you, Judge.
You're welcome.
Sir, during direct, you mentioned the word CPL, and so I guess my question is, are you in possession of a CPL?
No, I do not have one.
Have you ever had possession of a CPL?
No.
Are they trying to get him for CPL for carrying the gun in a zippered case?
Sir, you had an opportunity to review People's Exhibit number 1, correct? Which is and I will approach you with permission from your counsel and the judge. Your Honor, may I approach?
Yes, with exhibit, which,
People's Exhibit number one is a
Okay.
copy of the Supermatch Shooting Sports invoice.
okay,
Yeah, the back. That's not my invoice. Improper dates right on it.
Sir, do you recognize the invoice?
That you gave to me, correct?
You do recognize it. How do you recognize it?
You gave it to me last week.
Was that the first time you've ever observed a copy of the invoice associated with a Supermatch Shooting Sports, which includes a shipping method to yourself, and it goes on to include a specific address and phone number?
Right.
Sir, I'd like you, Your Honor, may I approach the witness?
you may.
Sir, briefly, I'd just like you to take a look at that exhibit and focus on the top left corner where it includes an address and a phone number. Do you see that?
So where's the
Yes,
shipping method?
excuse me, sir, it's yes or no?
Yes.
Okay,
Is that your address and phone number?
Yes.
And sir, during your opportunity to review that exhibit, which was stipulated to, did you observe the area where it has a description of the firearm in question? And is it your position that that is the firearm that you had recovered with your son when you both went to the store?
It's the same model number, but the date on that receipt does not align with the 19th. So I find that receipt cannot stand at any adherence in court because it's not a valid receipt. That was the day after.
Okay, and sir, I can respect your position. But my question is this a fair and accurate representation of the description associated as well as your name and address on the invoice?
That's not what the receipts look like from Supermatch. I have receipts with me from Supermatch and they don't look like that.
Sir, my question is the information associated with your address as well as the description accurate, that portion specifically?
The address for the purchaser is correct. Where it says shipment, there's quotations and nothing stated after that, so it was not shipped. And the phone number is correct. The model number of the firearm is correct. I did not see the serial number on that paper and compared it to agree to that.
Is the price associated with the purchase accurate? Okay. And are you familiar with a McKenzie?
Yes.
And who's McKenzie?
One of the attendants there.
And is that the attendant that you had made contact with at the time of the purchase of this firearm?
Not on the 19th.
Who did you make contact with on the 19th?
I don't recall their name.
Did you observe the firearm, the 6 Sauer? Did you observe that firearm on that day?
It was the case he had on the table.
Respectfully, sir,
No.
yes or no?
No.
And I draw your attention to the video that was introduced earlier. You stipulated to that introduction, correct?
Yes.
And that was you in the video, correct? And that was you who had that bag in your hand, correct?
Correct.
And that was you who turned over that bag to the officer, correct? And inside of that bag was that firearm, correct?
Correct.
And that firearm was the 6 Sauer, correct?
Correct.
And that 6 Sauer was the model 1911, correct? And that's the same firearm that's associated with the purchased firearm, correct?
Correct.
And that's the same firearm that's associated with the Supermatch Shooting Sports invoice, correct?
I don't know that. The date on that is wrong, so you cannot place me at that location at that date to accompany that invoice.
Sir?
We were not there on the 20th, so that receipt is meaningless.
Sir, you indicated that you and your son had gone to the store on May 19th to pick up the firearm, correct? And is it your testimony here that your son took possession of that firearm?
Dropped it, store, correct.
It's yes or no. Is it your testimony that your son took possession of that firearm? And you had both made that location in different vehicles,
Yes.
and you had not observed that firearm.
No.
It's your testimony here under oath that
It's arguments.
Your response?
Well, Judge, number one, respectfully, I would say this is cross-examination. Number two, I don't think anything I've posed to the defendant was argumentative. It seems that he's agreeing with all my questions. So respectfully, I would disagree with the defense's position, but I'll defer to.
The court would agree. The court, it seems, it may seem, it's a bit of a peppering of questions because it's a question and answer pretty quickly. But the court doesn't find that at this point it's argumentative. So the court's going to overrule the objection.
Thank you, Your Honor. Third, your testimony that your son had taken the firearm.
Okay, this is asked and answered, Judge. That's, I think, what I meant when I said argument. This is the third time he's asked about his son picking up the firearm.
Okay, so the court will sustain that.
Understood.
Okay.
Sir, do you know what your son did with the firearm after you both had gone to the store and he had picked it up?
He dropped it off to Christopher Murphy, who was a witness that was here multiple times and couldn't make it today.
Okay, so Christopher Murphy, that's the answer. Christopher Murphy. Next question, please.
And sir, when your son went to pick up the firearm from inside the store, what did you do?
I walked with him.
And so is it your testimony that you walked inside with him to pick up the firearm? Yes or no?
Yes.
And did you did that together? And you walked out together?
I think he left before me.
You indicated, I think. Are you guessing or are you positive of that testimony?
Can I explain it?
Sure, go ahead.
So when I was there was other firearms that I currently had deposits on and stuff. So I believe I stayed to settle that with them to see what I have to do, whether I can receive some money and how to handle that moving forward. And Christopher lives about an hour and a half from where we were. Pretty sure my son. I can't tell you exactly if he left with me or we both walked out at the same time. This has been four months ago going on. I'm sorry, I don't have the answer for you because I don't recall.
Well, thank you. I appreciate the honesty and the transparency that you don't recall. So I appreciate that very much. So my next question is, you indicated that you had other firearms at that location, is that correct?
That I had deposits on.
And where were those firearms?
Behind the counter, and they're safe.
And where are those firearms now?
With them still.
How many firearms?
Judge, I think we're getting away from the relevancy of whether or not he was in possession of a firearm after a court-ordered bond condition.
Your Honor, if I may respond.
You may respond.
Thank you. Your Honor, I had an opportunity with defense counsel present to review the bond conditions in this case. And Your Honor, what I saw that it was not only that the defendant could not possess firearms, but it also included a sentence, which I assumed was written by Your Honor, to turn over all firearms to the police department for safekeeping. If my recollection serves me correct. So again, Judge, I think we're diving into this bond violation, but there's more that meets the eye, and there might be more situations. It's not just that he may have purchased firearms, but it seems that he may still unlawfully possess firearms.
Well, okay, what I'm going to overrule the objection for the sole purpose of knowing the date those deposits were made.
Okay.
That's what this court would find relevant.
Sir, do you recall the dates associated with the deposits of those firearms?
Not off the top of my head.
Do you know whether or not that was before or after the arraignment in this case?
They were all before the arraignment.
That's all. You don't need anything else.
Sir,
Muhammad,
the testimony by the officer that you were present for suggested that there was an attempt to purchase a firearm. Are you familiar with that?
It wasn't an attempt to purchase
it was after I traded, there was a remaining balance I had on a gun that they were, I guess their process is to, in order for them to clear it, to take it out of my sale, because I explained to the people there that I could not possess it, I wanted my money back. So they had to submit it to see if it gets denied, and once it gets denied, you get your money back, and they returned to me $1,000 cash. And it was a Beowulf 50 caliber, I think it's long gun.
50 cal?
So, sir, did you trade any firearm after the arraignment in this case?
I sold.
You sold firearms. Who did you sell firearms to?
CNC Coin and Supermatch and my son.
And you recognize that you did that after the arraignment.
That's going to get him.
Correct?
Correct.
And you were present for the arraignment, correct?
Correct.
And you were aware of all the conditions the bond had placed at that time, correct?
Correct.
Yeah,
Can
he's
you
guilty now.
explain why you sold weapons knowing that the court had ordered to turn over weapons to the police department?
My attorney at the time, Matthew Savage, said that I have the legal right to sell my assets for money in a situation like this.
The judge's face
sir,
right there.
I guess my question is,
and so if I could finish.
Go ahead.
Every step I made with the firearms that were purchased and the ones that I've sold, I contacted Miss MSP and I asked for the proper steps to be handled.
You said you contacted Miss MSP?
Michigan State Police, so I knew how to pick up the firearms, how to sell the ones I had, not to have them in my vehicle, eliminate them from my home. Because nobody here gave me the steps on what to follow. So my lawyer told me that it would be smart to call MSP, and I called MSP. And when ATF came here, they were trying to indict me with ATF stated that I did everything textbook correctly.
Sir, respectfully, I'd ask you to testify to only.
I explained it.
I know, but there's rules associated with hearings, and I just ask you to, respect those. Because I recall that at a previous hearing, you had indicated to the court, and correct me if I'm wrong, that you're familiar with the rules of evidence, correct?
Not the rules of evidence.
Okay. What are you familiar with?
Okay. We're getting outside the scope.
I understand. I would.
All right. So next question, please.
So, sir, why did you not turn over the firearms to the police department since you were aware of the judge's order?
Asked and answered.
When I was in custody, my wife had borrowed money from several people. And I wasn't there to help with that. So we didn't have any money. So the first thing you do is you sell your assets. I didn't just sell the firearms that I had. I knew that firearms were metal and replaceable. I sold the vehicle that I had. I've been struggling financially since this. So I let a lot of assets go, and fortunately, firearms were the first thing that I did not need in my life, and those were the first to go. With consent of and permission of my lawyer, saying that I wasn't violating any laws, and MSP guided me in the process to sell these weapons and to pick up weapons that I further sold and turned into you. And I believe that if I should have been in any possession of a firearm, as if you're trying to pin a situation on me, Southgate police should never have asked me to put the firearm in my car and drive to the police station and then charge me with conducting traffic.
Sir, respectfully, again, I'm asking you to just
you asked the question.
State what another person said, the rules associated with that. Okay? All right. Thank you. So, sir, is it your testimony that you recognize that you did sell weapons and possess weapons after the court had imposed its conditions, correct?
Lawfully, yes.
Well, that's
It's yes or no. We don't need any adjectives or adverbs added onto that. Yes or no?
Yes, that question again.
You recognize that you were in possession and had sold weapons after the arraignment in this case. Yes or no?
Yes.
And you understand that you did not have permission of the court at that time, correct?
Is that a yes or no question? Because I don't know how to answer that question.
Okay, you've answered. He doesn't know how to answer that question. Yes,
I was gonna say, he's already testified that he relied on the advice of counsel.
that's the answer. Next question.
Well, Judge, my last question was a little different. I was more asking him that he didn't have consent of the court. I think I know the answer, but
Well, yes, he stated he doesn't know how to answer that question.
May I rephrase? Is that okay or not? Should I just move on?
Move on.
You can rephrase.
Thank you, Judge. Sir, at any point, did you have permission from the court to be in possession or to sell any guns? Yes or no?
I don't know how to answer that.
I think that was asked the exact same way, not restated, but that's okay. Go.
I'm sorry, I tried to change.
No, that's all right. Just
Just
you may,
move
you may
on.
continue.
Sir,
At what point do we decide it's a great idea to punish someone who's trying to follow all the rules that the court puts in place and has called the police, asked for their advice, has talked to the lawyer to figure out what he's supposed to do?
Sir,
why are we punishing him?
There's still firearms with Superman shooting sports on leeway?
I forfeited them. I took the loss of the money and I no longer have anything.
So is it your testimony that as of today's date, you do not possess any firearms?
None.
Any ammunition?
I have ammo. I did not know that was a court stipulation, but my safe is empty and it has some ammo.
Sir, why did you not pick up the firearm from Superman shooting sports when you went there with your son?
Because I'm not allowed to possess any firearms. This is exactly what Michigan State Police told me to do.
Okay. And in the video that was introduced into evidence, that was you who turned over the firearm to the police department, correct? Yes or no?
Yes.
Okay, and why did you not have your son turn over the firearm to the Southgate Police Department on that day?
Because the police officers told me to put it in my trunk, drive with it carefully, and bring it to the police station. My son went and picked it up from Christopher. And
again, sir, respectfully.
No, you asked
sorry,
why.
I don't want to cut you off, but anything you say that another person said is considered what we call hearsay. So I'd ask you to probably not to say what another person said, okay?
Okay.
Thank you.
So my answer is, officer, I don't believe it was Officer Kanowski. I can pull up the video from my Ring camera. Officer Kanowski was there. There was another officer. They came to my house at around noon, I want to say, or 11. And my mom called me on the phone and handed the police officer the phone. He stated that if I bring my firearm and turn it in, that they would tell the court that I am cooperating and doing everything, and they would come in here and tell the judge that I cooperate.
Again, you're talking about what somebody else told you, so that's hearsay.
Okay. Well, I was told to bring it in by an officer. That's your answer.
Thank you.
Again, that's hearsay. Counsel, next question.
Thank you, Judge. Sir, what type of firearm did you have in possession on May 7th, 2026? Was that a handgun 6-hour as well?
May 7th?
Yes, during the traffic stop in this case. What type of firearm were you in possession of? Was it a 6-hour?
Kimber.
A Kimber? And is that a pistol?
What's the relevance of this question?
Mr. Mohammed?
Well, Your Honor, I don't think
It's
that
a fishing expedition.
I'm precluded from asking this defendant.
What's the relevance to that question?
Well, I'm asking about the type of weapon. So I'm trying to see if this defendant is a collector of specifically 6-hours, handguns.
Okay, but what's the relevance to this proceeding? What is the relevance?
So, Your Honor, what's been introduced into evidence under People's Exhibit number 2 and People's Exhibit number 3, it appears to be specifically People's Exhibit number 3 is a 6-hour. People's Exhibit number 1 is a document that reflects the purchase of a 6-hour. So I'm trying to determine if this individual is a collector of these types of
What does
weapons?
that
Is
matter?
this a one-off thing? Is this a weapon that he may have, the weapons that he has in leeway that he indicated that he forfeited, are they all 6 hours? Because I guess I have this might be irrelevant, but my concern is he's making a number of purchases of firearms because what we have.
Legally.
Okay, here's what I'm going to rule. The court does not find that what gun was in Mr. Salem's possession on May 7th is relevant to these proceedings. So,
all right.
Next question. The court's going to sustain the objection.
Nothing further. Thank you, Judge.
Judge, I just have a quick follow-up, if I may.
You may.
Every gun you ever purchased, did you purchase it legally?
Absolutely.
And in the state of Michigan, to purchase a gun, you need a permit, right?
Permit and a 7-day clearance.
And a 7-day clearance, right?
Right.
And in this case, and in this case, in every other case, you did not have any unregistered firearms, right?
Correct.
And when you appeared in front of the court, it was your understanding that you could not have any firearms in your possession. Is that correct?
Right.
Okay. Could you have firearms on layaway?
I'm not sure.
Okay. Prosecutor referenced a gun that probably was still at the store, right?
Correct.
You indicated you put a deposit on it, right?
The 6 hour was paid off, and by when I was arrested, it just cleared at 7 day or 10. It usually takes up to 2 weeks for them to clear me.
Okay. In any event, the guns in the store aren't technically in your possession, right?
Correct.
Objection, Judge, this is leading. This is her witness. I don't believe it's appropriate for her to lead at this point because it is her witness, but I trust.
The court's going to give some leeway as it's a bond violation hearing and she's on redirect. So the court will give her some leeway. But counsel, just be aware as to how you're asking the questions. First, going to overrule the objection.
And so your understanding, and in the order, is it fair to say that in order to get any gun that you had on layaway out of the store, you would have to have money to get it out, right?
Correct.
Okay. So is it also fair to say that your understanding of the court's order was 2 things? You can't be in possession of firearms, turn in any firearms to the authorities, correct?
Correct.
And there was only 1 gun that you did bring to the Wyandotte Police Department, correct?
It was the only one that wasn't sold.
The only one that wasn't sold, right? And your
Had a huge
understanding of the
collection.
order, was it that you couldn't sell the firearms?
And that was not stated. It was just stated that I could not possess them.
And you consulted with counsel, right?
Counsel and
And you didn't sell these firearms on the street or to your friends, did you?
my son.
Objection, what is the relevance?
I will draw.
All right, the court will sustain the objection.
Since I have no further questions.
Good, I have just a couple. If I may. It'll be very brief.
Those are the famous last words of all attorneys on recross and redirect, but okay.
Thank you, Judge. Sir, you indicated that you had purchased the firearms legally, correct?
Correct.
Can you explain why 2 different weapons have 2 different license numbers or the same exact license numbers?
Absolutely, because it took me a while to figure that out too, because I wasn't aware. Any firearms that I purchased, or let me rephrase that, any firearms that I picked up after my court date of my bond hearing, I asked the people at the counter to make me multiple copies of, so I have more than 1 copy of. The guy that I was talking to at the time made copies of, I believe it was at Supermatch. He made multiple copies of the purchase permit while it was blank.
Respectfully, sir, please, unless you know.
I'm telling you.
Okay, just 1 moment. We're not having everybody all the time. You asked him to explain. So he's explaining how 1 license number is on 2 exhibits. So please continue.
And he accidentally copied them before. So, and to make clear of that.
Excuse me.
Oh, sorry.
Copied before what?
Before The transaction was like, I wanted copies of the
Sir,
purchase
I'm just asking before one. I'm not asking for a whole scenario.
before the paperwork was filled out.
Okay, there we go. All right, Mr. Mohammed, you may continue.
Sir, you indicated that that individual accidentally made a copy. How do you know what he did was accidental, and how do you know what his intention was? Did you speak to him regarding the matter?
At the time,
Yes or no?
These are not yes or no questions. These are
Did you speak
explanations.
to him regarding the matter? Yes or no?
No,
So how do you know that it was accidental?
because I had multiple copies of the same purchase permit, but I also had multiple copies of unused purchase permits.
So are you?
So when he handed me my paperwork, I just put it in the envelope. I didn't go through and how often do you get a duplicate blank? Who copies your purchase permit? Why would I use a clone purchase permit when I have multiple unused purchase permits?
Okay, all right. I think that we've gone beyond the scope of the bond violation. All right. Council, next question.
If they stick this guy with this bond violation, I'm going to
Sir,
be
have
mad
you
all
ever
weekend.
used fraud or deceit in order to purchase any of the firearms?
Absolutely not.
No further questions.
Okay, I have a few questions. So,
She's more worried about the bond instructions and what she told him. What part of no
sir, how
ammo
old is your son?
do you understand?
He is 20.
20?
And when did you sell the firearms?
Almost immediately after being released.
Okay, so what does that mean? Within 24 hours, within 7 days?
I would say within 7 days to 2 weeks, but all the firearms.
Okay, that answers the question.
Yep. He's busted.
I don't know exactly. They were sold.
Okay, that answers the question. All right, so then, you went to Supermatch and CC Coins on the same day to pick up these firearms?
Yes.
When you stated that you, spoke to Michigan State Police and Southgate Police Department, did you tell any of those individuals that you asked that you were prohibited from possessing, purchasing, or having access to guns? Yes or no?
Can you repeat that near the beginning?
Did you tell anyone at the Michigan State Police or at the Southgate Police Department that you were prohibited from possessing, purchasing, or having access to guns?
With MSP?
Yes or no?
Yes to MSP. I don't know if I had that conversation with Southgate. Actually, I did. I told them that. I remember now. I told them I could not drive with it, and they told me just.
No. I didn't ask if you told them you couldn't drive with it.
Okay. I told them I could not possess it.
But which is it? You told them you couldn't drive with it, or you told them you couldn't possess it?
I told Southgate I could not drive with it, and he still insisted that I put it in my trunk and bring it up there to show cooperation.
Cooperation with the bond.
Sir, you received a copy of this bond condition sheet, correct?
No, I did not.
You did not.
I did not.
You did not receive a copy that looks, this is a blank copy, but you didn't receive anything that looks like this.
I did not. I did not.
When bond was posted, where were you? Were you still in Wyandotte Police Department, or were you at Wayne County Jail?
I think I was I had to post my bond, and then they transported me to Wayne County.
Okay, so bond was posted here.
Yes.
All right, and then your paperwork goes with you there. Do you recall this court ordering you not to possess or have access to firearms or weapons? Do you remember that?
Yes, Your Honor.
Do you remember the court ordering all weapons are to be turned to Wyandotte Police Department for safekeeping?
That's right.
So, your testimony is that you did not turn in all weapons to the Wyandotte Police Department. You, in fact, sold some weapons after you were released. Yes or no?
Yes.
Okay. And then you also, prior to your arraignment, you had 4 guns in layaway, correct?
Yes.
And so then upon your release from custody, you still, excuse me, sir. You took possession of 2 of those and 2 remained in the possession of the stores.
I physically did not take possession of it.
All right, so your son took 1 to the friend. Where did the other one go? Oh, how did the other one get into your possession for you to take it to the Southgate Police Department?
So my son brought it to me. My son went and picked it up from Chris's house.
So both guns were taken to Chris's house?
No, my son bought the other one.
Which gun did your son buy?
AR pistol.
The one from CC Coins.
Yes.
Yeah, they're going to
May I
violate
say
it.
something here now?
Nope.
You may not. Do those questions elicit any further questions by the defense?
No, Your Honor.
It's her witness, that's why she goes first.
I forgot.
No, Your Honor.
Okay. By the people.
Yes. Sir, what is your son's name?
Salem.
And you indicated, did you say he was 20 years old?
Yes.
And
He has to be
when's his
21.
birthday?
The 24th.
Are you familiar with the age associated with the purchase of handguns?
18 and up.
How confident are you in that?
100%. Look it up. They can buy them privately. They just can't buy them from the store.
And
I gave them the purchase permits for them. I have copies of my copies of those.
And the firearm that was picked up from Supermatch Shooting Sports, what type of firearm was that?
That was a pistol.
And what
Did not buy that one.
I'm sorry?
He didn't buy that one.
Did he pick it up?
Yes.
And do you know whether or not he's legally allowed to pick up a firearm being under the age limit of the purchase?
Judge, what is the relevance of this question as to whether
Hold on, sir, there's an objection, so you have to pause any answer.
he violated his
So his son might be in violation under.
Well, Judge, again, if the age limit to purchase a pistol is 21,
It's not.
Sir,
Sorry.
you cannot respond right now.
Sorry.
Thank you.
if the age limit associated with the purchase of a pistol is 21, I understand there's some exceptions when an individual is 18. If it's
the
being,
prosecutor's testifying.
I'm answering the court's question.
Excuse me, I'm not having you both go back and forth. This is the response to your objection for relevancy.
So, Judge, if the age limit to purchase a pistol from a public place such as Supermatch Shooting Sports is 21, I'm starting to have concerns that his son actually picked up the firearm, because if the age have to be 21 and he's 20, then I think we may need to call additional witnesses to see whether or not this firearm was actually released to his son, because it appeared, and I'm sorry, I wasn't too familiar on the issue beforehand, but it was brought to my knowledge by the OIC, but the age limit from a public store is 21 to purchase a firearm, and if his son, if he's indicating here under oath that it was his son who picked up the firearm,
Again, you cannot interject.
I'm sorry.
and his age is 20, I don't know if the store actually released that firearm to his son, so that's, I guess, the basis of my question, to make a record of the situation and to.
Well, the court does find, based upon that the question is relevant for credibility purposes, for sure. So the court's going to overrule the objection.
Yeah, his son's now in trouble too, potentially. Okay, there's also straw man buyer laws in almost every state that you can't buy a gun to give to someone else. They would have turned the gun over to him. Not like I paid for it, now someone's going to come pick it up and just let them have it.
Sir, it is your testimony that your son picked up that firearm in that day.
He did not purchase it.
I know, you're saying that he picked it up though,
He picked it up with me.
and it's your testimony that you purchased it.
I did. And he took it to a friend's to hold until court was resolved, until Southgate Police called.
I didn't ask that. You purchased the firearm, correct?
Yes.
When did you purchase that firearm?
Now, this was.
Okay, this was before the arraignment. Next question. The court's going to sustain the objection.
Sir, what happened with that firearm after, how do you know that that firearm was transported to Christopher's home? How do you know that?
I told him to take it there
Why did you tell him to take it there?
because we couldn't possess it and he didn't want to buy it.
Who didn't want to buy it?
My son didn't want to buy that firearm.
How do you know that?
Guys? Do I have to answer this?
Sir, you took the
Just
stand.
a moment. There's an objection.
I'm sorry, I'm really tired. But you're not. Relevance, Judge, relevance. At some point, the court just needs to decide whether or not he violated the conditions of his right. Whether his son, how he knew where he went, where he took it. We are getting so far afield of the real question. I feel you might have to make me dinner tonight. I'm just joking.
I've already made people breakfast and lunch today, so I'm not doing that. But the court's going to agree that there's no relevance to that question. The court's going to sustain the objection.
In your honor, I will respect the court's ruling, and if I may just slightly attempt to sway the court to reconsider.
There's nothing that's going to make me reconsider. So next question.
Okay. Sir, did you attempt to sell the firearm to your son after the arraignment?
No. Well, I don't know how to answer that properly because you're asking me a yes or no question and I don't have a yes or no answer for you.
Did you attempt to sell it to your son? Are you not able to answer a yes or no to that?
Because it's not a yes or no question. Yes or no answer on my side. There's more to it.
Okay, go ahead and explain.
I asked him if there's something he wanted to buy before I sold it. And he doesn't like pistols like that, so he chose not to.
Why did you ask him that?
Judge. Okay, the court doesn't find that there's relevance to that. Is there any, you're going far afield of the question that this court asked, and that's what your follow-up questions are to be contained within, or the question that this court asked.
Just one more question. Sir, can you identify the 4 weapons that were on layaway at the Super Match Shooting Sports? What were those 4 firearms?
I believe it was a 50 Bagel rifle. They were not all at Super Match, by the way. It was
That's a big gun.
A long rifle. I believe there was 2 long rifles. One of them is a sniper. One was the SIG.
Like a 308.
If I can dig through my report.
What's this guy's original? What's his
I don't find that that's
offense?
necessary for this court's ruling at this point.
I promise, Judge, last question.
We said that last time, but
No, I apologize. Sir, how many SIGs did you possess at one time?
and you need to clarify which time frame you're speaking of, counsel.
Since the arraignment.
One. That one.
Understood. Nothing further. Thank you.
Anything else, counsel?
No,
Yes, you may sit down. Any further witnesses for the defense?
no,
All right, any further witnesses for the people?
No, thank you, Judge.
All right,
He's going to be in violation.
okay.
Even though we bent over backwards to follow the
Arguments by the
rules.
people.
Your Honor, the testimony in this case, I believe, supports that a bond violation had occurred. I'll leave it to Your Honor's discretion to make that determination, but I think there's sufficient testimony. I will say that it is based on my assessment that there were certain moments during the defendant's testimony that suggest that he wasn't credible. However, I will again defer to the court's discretion and assessment as that you've seen a number of witnesses provide testimony. So I think the record speaks for itself and I'll defer to the court's discretion.
Great, and, Ms. Longstreet?
Judge, I will defer to your discretion. Also, just give me a little latitude. I didn't know much about this case before I got here today. Quite frankly, I've been managing the record at DS for about 3 years, so I don't have cases. But I was a public defender for 17 years. And when I met Mr. Salam, and he told me the ATF was here asking about his purchase of weapons, I found it. I'm going for it. It's gonna go to the bond, right? Because one of the things that we do in reference to setting bond, right, is you want Mr. Salam to abide by the court's order, but it's a purpose to it, right? Because I get this case involved a firearm, right? And I'm looking at the file and I see originally CCW, felony firearm, and a possession charge, right? And then I discovered that he doesn't have a prior. So that's not an issue, because normally you see the felony firearms tied to some prior felony offense. That's not the case. The gun he had, legal gun, registered. It wasn't a street gun, which in my 17 years, I promise you, I've seen a lot of street guns, right? I've never seen or met a client who is so knowledgeable about the purchase of guns, whether we think he should have them, whether we think he should be purchasing so many guns, whether we think based on maybe where he's from, whether or not he should be given a permit to have guns. I'm somewhat offended because this doesn't happen all the time. And so the only thing I want to say to the court is, welcome back to really arguing on behalf of a client here. And I know the court respect of the court's orders. If we don't have that, we don't have anything. But I will ask the court to look at everything Mr. Salam has done. Every purchase of a gun was legal. He had a valid permit. When the court told him, you can't have possession of a weapon, turn it into the police, he did that. He didn't try to run. He didn't try to take it to someone else's house. And it was registered and legal. And so I understand that the court is looking at this and thinking, this is a close call. I told him he's not supposed to have any weapons, right? So he gets out of jail. He has these weapons that he's begun the purchase of, right? He doesn't want to lose his money, which is sort of like a fact of life for people who find themselves in the system after he's already been locked up, 6 kids white, paid a bond, is trying to make up for something he did wrong. And the reason why I am advocating so strongly in this case, because this is a man they offered a misdemeanor to this morning, right? And so, and he struggled with it because he's like, I get out here. But the system is beating him up because now we're spending 2 months on a bond hearing for someone that they just offered to a misdemeanor. And I don't know, the court may not take that into consideration in the calculation, but I hope the court sees more than someone who violated a bond condition in a case where he was just offered probation and a misdemeanor. Thank you, Judge.
All right, thank you.
Your Honor, may I briefly respond to that?
Okay.
With all due respect, I don't believe that my office extending a resolution in this case should be used as weight to deny a bond violation. One thing I've learned during my few years as an attorney is that the court speaks through its orders. And Your Honor, you spoke through your order when you ordered the defendant not to possess any firearms, and if he does possess firearms, to turn it over to the police department for safekeeping. We need to respect the order of the court, and we have to respect the judge and her requests and order. And in this case, you ordered the defendant not to possess any firearms.
You also ordered him to turn over the guns to the police department. To me, based off of the testimony, it shows that the defendant did not comply with that order. I will leave that for you to decide, Your Honor. I've asked to just, the testimony speak for itself, but this isn't a situation where we're attempting to punish the defendant or anything. This is the law, and we have to follow the law, and we have to follow the court's orders. And so I'll reserve any further argument, but I just wanted to highlight that for the court. Thank you.
Okay, thank you. All right, the court heard testimony as well as reviewed the stipulated exhibits and the video. It is clear that this court's order was for Mr. Salem to not possess or have access to any firearms and or any weapons. And all weapons were to be turned over to Wyandotte Police Department for safekeeping. Now, the court will give some consideration to Mr. Salem not having a copy of this. Somehow the Wayne County Jail didn't provide that to him, which is a problem. And that's only in regards to purchasing a firearm. Because on item 11 on the back page of the bond conditions, it reiterates not possess or purchase a firearm or other dangerous weapon. So that just sort of clarifies what this court had previously put in here on page 10. So what this court's focus is on is the disregard for this court's order. First, this court ordered all weapons to Wyandotte PD for safekeeping. If there is a request to sell those items, those firearms, there should have been a motion appropriately filed before the court. The court will also will note that there is some credibility concerns with Mr. Salem as it relates to his testimony that his son was in possession of the guns, because now it's a concern as to whether or not his son legally had the ability to have the guns, and whether or not or Mr. Salem was a front for the purchaser, but then to provide those with it's not a time to responsor to provide it to his son. The court will also note that the testimony was that Mr. Salem had multiple purchase permits. Further, that there were multiple guns in layaway, and I believe the testimony was that he received refunds on some of those,
and refunds
of deposits on some of those that were still at the store, and others that he lost his deposits on and no longer purchased the guns. The concern that this court also has is that Mr. Salem seems to have contacted his prior attorney, Michigan State Police, as well as Southgate Police Department, all of which were not Wyandotte Police Department, which is where this court ordered the weapons were to be turned for safekeeping. Further, if there is an issue regarding the guns that were in layaway, that could have been addressed at the arraignment. And there could have been more clarification. And that, I don't believe that was brought to the attention of the court at all. But given the nature of the charges in this matter that the court had at the time, that, and this is what this court's basing the bond violation hearing on, because that's where the court set these conditions for bond. What's happened since then, whether there's been charges dismissed, offers made, is not relevant for this court's ruling today. So the court is going to find Mr. Salem guilty for violating this court's bond conditions.
Revoke his bond. Okay, Michigan's off the list. Can't go to Michigan.
And the court's going to court's going to order 7 days jail. For violation of this court's order.
Judge,
I will give you a date to report. Yes.
I was gonna ask about the exam. I thought you were finished.
Okay, I will give you a date to report. You can report
In the next 30 or 14 days.
Monday, July 27th.
Oh, he gets the weekend.
Yes, counsel.
Your Honor, if I may, I don't know if you're referring to me or defense.
No, Ms. Longstreet wanted to address the exam.
I want to at least schedule a thing for exam. I have to take out
We kept it today.
it's fine. Judge, I respectfully asking for another date for the exam. I will tell the court that, this is bond hearing, a lot of information I didn't have the benefit of, and my understanding is with the other case, Mr. Salem may have filed a motion, he has some other things, and I want his grievances to be heard, and I want him to have a full and fair opportunity before the court. So I'm asking for a exam date.
Okay, your response, Mr. Mohammed.
I guess I'm not fully comprehending what defense counsel is asking me.
She's asking to adjourn the exam so that she can go over newly discovered information that she did not have access to or privy to prior to the bond violation hearing today. Is that accurate, counsel?
That is.
Okay, that's what she's asking.
Judge, I'll defer to the court's discretion, but I will not agree to it. But what I will say, Judge, and I do need to make a very clear record, is this is a request, as your Honor is aware, just for the record, this is a request coming from the defense. We are prepared again. This is the third preliminary examination where the prosecution has had all witnesses present. We've been prepared to move forward with the exam every single time. However, we will defer to your Honor's discretion. There is one additional thing I'd like to address regarding bond, but I'll wait for the court's decision as to the defense's request to adjourn again.
Judge, do you want me to respond?
Well, just for clarity, we are ready to go today.
I understand. But I also understand too that
Defendant has a right for a fair trial.
that given the issues that are occurring at the Neighborhood Defender Services as well, that and given the newly discovered evidence that it appears both sides have learned today that it's not an unreasonable request. I'm also very keenly aware that officers have once again been present all day, prepared for this exam. The court's also keenly aware that it's 5 o'clock.
It's 5 o'clock somewhere.
The delay this time isn't necessarily the court. It was issues with defense counsel, not specifically Ms. Longstreet, but Neighborhood Defender Services in general, not having apparently the appropriate information to have appeared. And then it wasn't, we didn't even begin things until after 1 o'clock. This was originally scheduled to begin at 11:30. And given how the bond violation, the tenor of the bond violation, the court has to take into consideration the timing for all involved, including the court staff. So I am going to grant defense request for an adjournment.
I want to follow this one.
If there's going, I will say that the motion that's currently filed is not, something this court's going to, accept. And so, just so there's not any misunderstandings and we can be clear, the motion that was filed on July 22nd, this court already ruled was not properly filed because it was not timely. So that motion is not going to be moved forward on. Now, if either side's filing motions post today's date, that's something different. But the July 22nd motion that was filed is not proceeding because it was not timely filed. Nor was there a request made for the court to determine if there was good cause to waive the requirements under 2.119.
Understood, Your Honor.
Okay,
I'm just gonna look at my calendar on my phone.
okay.
Court's not give us a date.
Well, I am, but we're looking at least now there's only a couple witnesses you have to coordinate with counsel and not 7 or whatever the number was before.
Sure.
We're looking at August 27th or August 27th.
Judge, I would have no objection to Thursday, August 27th.
Yes.
What time?
Well, I'd like to say 10 a.m., but I don't know, Alicia.
Thursday?
It's a Thursday. Does that work for your witnesses, Mr. Mohammed?
I can go check. There's fully sitting in the car.
Okay.
The judge wants to go home. It's frustrating. I think as we look at Lady Justice, right? She's wearing a blindfold, right? So it's blind justice. Everyone, the law should treat everyone equally.
While we're waiting, is it that you want Mr. Salem to turn himself into the court or the jail on Monday?
He will,
You know where the other officer.
he will have to,
So judge.
he'll have to communicate with probation to get that information, as to the procedure, but it will be at the jail.
Judge, Officer Harris will not be available that day. It's my understanding that he's anticipating the birth of his child on August 29th.
Well, that's completely unacceptable. How do you know she's gonna go early? I'm kidding. I'm kidding.
That pushes another month then.
Okay.
Anyway, the blind
So
justice.
should you spell your first name with a K or a C? Okay. Okay.
I'm gonna let him just.
Kristine.
Oh, we have to hear the date.
Okay.
Sorry, hang on. We have to hear this date. September.
Okay. How much time off?
I will be off till October 1st.
Of course you will be. As you should be, to be quite frank. Okay, we can't go that far out. Well, there's the other option is, well, are you off that whole week before the birth?
The birth is this Thursday, or Wednesday.
Oh, I thought, oh, you meant the 29th of July.
Correct.
Oh, and you're off until October? Good for you. Wow.
It's
That's fantastic, actually.
I guess, Judge, my concern with an adjournment at this point would be some sort of speedy violation. That's why I'm hesitant to now agree to an adjournment, considering
There's no trickery over here, Mr. Muhammad. Mister.
If the defendant is stipulating to this future date and any potential type of.
Hold on, you know what? Something occurred to me a short time ago. I'm gonna see counsel and chambers. Let's go off the record.
All right.
Just remembered I got a bottle of Jim Beam on the rack back there. I hope we can find the date.
Sure. Moving forward.
Let's see what the date is. Hang on. There we go. They're coming back from whatever just happened in chambers. Yeah, I'm not Muhammad's biggest fan here. I'm just saying he may have technically violated his rules, and I think the judge is right in finding that. But I think it's very rare to see someone who has tried so hard to follow all the rules and with all the contact with the police and with the lawyers and everything else, and him not having a copy of the bond conditions, that to violate him on this one and make him serve 7 days. Does Muhammad just have an agenda? Is he like anti-gun? What is it? Clearly, it sounds like the police department has an issue with him. Yeah, Georgia's off, Michigan's off.
All right, so we are back on the record in the matter of the state of Michigan versus Mohammed Salem 26586. An appearance for the people, please.
Good afternoon, Your Honor. Mohammed on behalf of the people.
Oh, it's about good evening at this point, but yes, okay.
Christy Longstreet.
Mohammed said.
Very good, thank you. All right, so the court did have significant discussions in chambers regarding some of the challenges that it's had to, that we've had to navigate in relation to scheduling an adjourned date. So it's been agreed upon that it's going to be Tuesday, July 28th at 10 o'clock in the morning.
Oh.
And the court's going to, sir, amend your report date to the Tuesday later in the afternoon or evening or whatever.
So no matter what happens to that.
So you don't have to go on Monday. We're going to contact the court, or we're going to contact the jail, amend the paperwork that was sent down to that end. Okay?
Okay. Be here at 10 o'clock sharp Tuesday.
Yes. Bonding conditions are continuing.
If I may, there's just a couple of things.
No.
My apologies.
Okay.
Thank you. Your Honor, considering the history and but as far as the preliminary examinations, at this time, I'd like to place on the record and invoke the prosecution's right to a speedy trial. At this time, we're not claiming there's been any violations. However, to ensure moving forward, the case continues to proceed as it should. We're just invoking that right. It is our constitutional right as well. As well as I'd like to also state on the record that our position as the bond, if I may address that as well.
All right, just a moment. The court is going to indicate that it's this court's intention that this matter move forward. The court has also stated on a number of occasions regarding the procedural history of this matter that there have been various reasons why the exam has not proceeded on the scheduled date. The court will also note that it is taking into account and into consideration both the prosecution's right and the defense right to a speedy trial. And that is why we are pushing this for Tuesday. Hopefully, the baby doesn't want to come out before that. So.
And I want to thank you, Your Honor, for accommodating all parties in this case throughout the entirety. The court has done amazing in that aspect. I did want to address bond, specifically the GPS debit. So it's my understanding, at the last hearing, we did defer to the court's discretion. However, considering in light of the case or the new bond violation, we are requesting that the defendant have a GPS tether imposed. Our concern is, one, that he could potentially flee the state. Additionally, as the record reflected and the violation reflected, he had disregarded.
Please be careful because that's going right into my court reporter's ears.
The defendant had previously disregarded the orders of the court, and so we do believe that, one, he poses a potential flight risk, considering his prior, what the testimony reflected in the bond violation, that he's disregarded the orders of the court. So there's a concern for that. Additionally, there's a concern considering the fact that a purchase license number was used multiple times. I understand the defendant had testified that it was due to another person making a copy, but we don't know that for certain. There's been no testimony by that other person. My concern is he's going to other states, potentially purchasing firearms, potentially selling firearms. We don't know.
You don't know that.
To address that concern, I think a GPS tether, which requires him to be here in the state, should be imposed. It will monitor the defendant's location, as well as it will ensure that he will not be a flight risk and disregard the court's order to remain in the state of Michigan, as well as now the court has sentenced the defendant to 7 days in jail. And so to ensure all of this, I'd request that the bond reflect a GPS tether considering the totality of the circumstances, both the disregard of the court's order, the testimony in this case, and the violation the court had found. Thank you.
Okay. Before I give you an opportunity to respond, counsel, Mr. Mohammed, is there any information that you have that this court hasn't heard already that would give
concern,
support to your concerns or fears that Mr. Salem is going to leave the state?
So, Judge, my concerns are based.
No, that was not my question.
There's been no additional information outside what the record reflected through the bond violation and the arguments that I've put forth. My request is based off of, one, the court's now found the defendant to disregard the order of the court. Additionally, there's been testimony taken by the defendant where he doesn't appear to be a credible person. Additionally, the court has now sentenced the defendant to 7 days in jail. Considering all of that in its light, I think that a GPS tether to ensure that the defendant is appearing for the court hearings as well as his jail sentence, that's what the GPS is going to do. It's going to ensure his presence. There's a license number that was used.
Right, but counsel, how is the GPS tether going to prevent that? Because if I recall correctly, he was on a GPS tether when he was in the store, right?
Yeah.
Yes, Judge. But what it does is it goes to I'm sorry?
Go ahead.
Judge, I'm relying again based off of the testimony and what the court has found. In light of that, that's why I'm making my request.
Judge, I'm gonna make a record. I'm trying not to be offended for Mr. Salem, but if anything, he's here before the prosecutor. He's sending you motions. This idea that somehow he wouldn't appear at court, he's representing himself. He turned the gun in. The guns he's purchased, he's all done it legally. I don't know where we made this left into making the fact that he may have violated a bond condition, right? Not that he fled, not that he wasn't at court on time, not that he went somewhere out and escaped, and all these suggestions, if you got charges, bring them. I heard the
counsel, address the court, not Mr. Mohammed.
Okay, I heard that the ATF was here to talk to him. If they have charges, they should bring him. He doesn't need a GPS tether. The court has given him 7 days for the violation. He's here now. He's been here. He was here before me. And he was emailing, filing his own motions. That's not an issue. And as the court pointed out, he had a GPS tether when he apparently went into the gunshot. I'll stop.
Judge, if I may, if we're focusing purely on the history, we have to also acknowledge there was a previous hearing where the defendant failed to appear, right? I'm not relying on that solely. I'm actually giving that the least amount of weight in this argument, because at that time I had not even motioned for a capias, because I looked at the totality of the situation we had before us. He had appeared in court on that day, not before the actual court, but he had submitted motions. So I didn't think his intention at that time was to evade. It's normal, typical behavior to for a prosecutor or the court to issue a bench warrant when an individual fails to appear. But what we did, Judge, on that day is we assessed the situation and we made a decision based off of what we believed at that time.
Who's we?
Well, Judge, I didn't motion for a capias and Your Honor didn't issue a bench warrant on that day.
Right, but I will state for the record that you and I were not discussing collectively and made a decision as to what direction to go to. So I just wanted to clarify that for the record, that you're saying we.
There's no I in we.
That's not you and I, you and the court together are making that decision. I just want that to be clear for the record.
Absolutely, Judge. Everything was on the record, but I recall speaking on the record and saying that it wasn't based off of my assessment of the situation. It wasn't the defendant's intention at that time to evade the court. So based on that, I did not motion for a capias. Right. And the court seemed to agree with that assessment, which is why the court didn't. And I apologize for speculating on the court's behalf, but that's just what I gathered based at that time. What I'm trying to say, Judge, is we take every case by way of saying the prosecution, case by case, based on the facts at that time. And as of this moment, there has been a change in circumstances. That change is what the testimony reflected. The defendant had acknowledged being in possession of a firearm without a CPL. That was reflected on the record. What's also changed, the court has now found the defendant in violation of the court's order. The defendant had disregarded an order of the court. That is a fact. And so when there is now a history of, now I am giving that previous failure to appear a little more weight than I did at that time. Now I'm not relying on that solely, but it's a factor to consider along with everything in its totality. And so now that the defendant is facing 7 days jail, there's been a clear disregard of the court's order and all the factors I've already mentioned. Based on that, I think there should be a GPS tether imposed. I'm not saying that we should now change this to a cash bond and he should, his bond should be revoked permanently pending this case. All I'm saying is this change in circumstances, based on my assessment, warrants a monitoring of the defendant's location. I'll defer to the court's discretion, but that is just the position of my office at this time, considering the new information.
Okay. And it is the position of this court that I do not find that there has been a sufficient change in circumstance to warrant Mr. Salem having a GPS tether put on at this time. The court will note that they did grant the request on July 16th to remove the tether. That at that time, Mr. Salem was still pending the bond violation as well. The court will also note that Mr. Salem has his, usually it's his wife, his spouse, and 6 children locally here as well, and that there is not any prior failure to appear history, even when he had matters in the circuit court that he had to appear on in jury trial or something of that nature. I don't show anything in his criminal history of any failure to appear history. So bond and current conditions are continued.
Thank you, Judge.
Thank you. Have a good day.
Thank you.
Off the record.
So Tuesday, we have to come back on Tuesday. Hold, please, for just a minute. All right. I'm not saying I hope he runs over a nail in the parking lot. I'm not saying I hope the cashier at Walmart charges him triple for his groceries. I didn't say that. I'm not saying I hope he swallows a bug on his next bike ride. I didn't say any of those things. But if one of those things happened, couldn't happen to a better person. I mean, honestly, salt of the earth. What a gentleman. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. Please stay safe to be alive. Monday morning, we'll be back. And now we have to look at this on Tuesday. We're looking for another case. We'll be one of those shortly. No, we're not going to do the mom on 11 different drugs that killed her 4 kids. I'm sorry. We cannot do that one. That's not for us. There are other people that will. That's great. I highly recommend Trial TV Live. Chris and Aaron are fantastic. They're going to be covering that one. Guys, have a great weekend. Be good to each other. Mods, you're amazing. Thank you. Everyone be good.